Okay, good morning, everyone. I think we will begin. We have a hard-earned reputation at the law school for doing things on time. That includes both the beginning and the ending, and you may rely on that. My name is Joseph Kearney, and it is a great privilege for me to welcome you to Eckstein Hall and to today's conference, Campaign Finance in Wisconsin, the law as it was, is, should be, and will be. My welcome is not just for myself as Dean of Marquette University Law School, but also on behalf of my fellow conference organizers as well. In addition to Mike Goucher, Distinguished Fellow in Law and Public Policy here at the law school, they are leaders of the Milwaukee Lawyers Chapter of the Federalist Society and of the American Constitution Society. I want to mention them at the outset. The Federalist Society leaders are Dan Kelly, a lawyer at Rogan Kelly in Waukesha, and C.J. Safer, a lawyer at the Wisconsin Institute for Law and Liberty. I see C.J. sitting in the first row, and Dan is in the second row over there. Those from the American Constitution Society are Jim Gramling, a retired Milwaukee Municipal Court judge, and Mike Sperling of Sperling Law Offices here in Milwaukee. I know they're here because they did things this morning, but they're in the back. If the event goes really well, they're going to move down to the front at the beginning, but they're cautious folks. I am really quite grateful to all of them for their work with Mike Goucher and me and the law school more generally in planning this conference and on an aggressive time frame. We are going to proceed in 3 sessions as set forth in your conference materials. The first session gets at the first 2 verbs in the conference title, the law as it was and as it is. The difference in tense, the use of both past and present, does not so much refer to revisions in statutes or regulations made over the course of time in Madison, that is by the legislature or its duly created administrative agencies, most recently the Government Accountability Board. To be sure, there has been some of that revision over the years. But we say the law, not just as it was, but also as it is, in order to allude to changes in Wisconsin law because of the actions of another part of the government, specifically the judiciary. One does not have to be an expert in campaign finance law, and few of us here this morning are, in order to be aware that invoking and interpreting and applying the First Amendment, the federal courts, including the U.S. Supreme Court, have handed down important decisions on the law of campaign finance over the past 40 years or more. The pace of litigation, the scope of change from the law as it was initially written has increased in recent years. The conference materials will give you a sense of this. We begin with Chapter 11 of the Wisconsin statutes and follow with regulations of the Government Accountability Board. That's a good start, but we have to follow those with a set of decisions from the federal courts concerning those statutes and regulations. In particular, you can see in the materials 2 decisions of the U.S. Court of Appeals for the 7th Circuit, both authored by Judge Diane Sykes, who's watching over us today, only in the form of her portrait. In the Wisconsin Right to Life versus Barlin litigation, one decision having been handed down in 2011 and a second in 2014 after a remand to the district court. Then, and actually printed before these in the materials, there is the permanent injunction in that litigation entered by U.S. District Judge Charles Clavert less than a month ago. I am tempted to say that no doubt you have come well prepared to class, having read all of this as we distributed these materials electronically earlier this week to those who had registered. In all events, you have the materials now, and at no cost. Fortunately, we have some great teachers with us today, and they will educate even those of us who did not do all of the homework This begins with our first panel, which is intended to give us a tutorial on the law of campaign finance in Wisconsin, the was, and more importantly, the is. And I would ask the two individuals whom I'm about to introduce to come up as I do so. We told them a few moments ago that their microphones were live from the minute I started speaking, so I know that they're ready. So as they get seated here, let me introduce them. One of the individuals, the one who is closer to me here, is Rick Essenberg, a longtime member of the Marquette Law School faculty, both on a part-time basis and for several years on a full-time basis, and also a former partner at Foley & Lardner. In recent years, Rick's full-time work has been as the founder and president of the Wisconsin Institute for Law and Liberty, which is a nonprofit law firm dedicated to the promotion of free markets, limited government, individual liberty, and a robust civil society. You can also find him often in the newspaper. The other panelist is Matt O'Neill, who is a partner at the Milwaukee law firm Fox O'Neill and Shannon. Matt previously was a partner with the law firm of Freebert, Finnerty, and St. John, and began his career after graduating from Marquette Law School as a law clerk to Chief Justice Nathan Heffernan of the Wisconsin Supreme Court. Matt has handled many campaign finance and election law cases, representing folks on both sides of the aisle, including litigation on behalf of the Democratic Party of Wisconsin in voters' rights cases. So Rick and Matt are well matched, and I'm very grateful that they agreed not just to be part of today's conference, but to do this session together. This is the way that I teach all of my own classes. Tom Schreiner and I are next to one another, and we are there to elaborate upon, or, if you know Tom, to correct a point that the other has made. That would be Tom correcting me, and maybe even to provide some good humor along the way. To be sure, we're usually a little harder on folks who did not do the reading than I expect is going to be the case this morning. So we're going to give Rick and Matt until 9:15 a.m., and I know that they intend to reserve part of that time for questions from the floor. Then we will take a break, an unusually long one by our standards, all of 15 minutes, to 9:30 a.m., whereupon we will pick up again. So without more, please join me in welcoming Matt O'Neill and Rick Essenberg.
So we're going to go back and forth, and to help you follow along, Matt observed this morning that it was appropriate that I wore a red tie and that he wore a blue shirt, so you know where we're coming from. I'm really happy to talk about campaign finance law. After testifying earlier this week at the Right to Work hearing, I'm happy to discuss something that is, not controversial, like, Citizens United and John Doe. I want to start by talking a little bit about the framework of campaign finance law. I do a lot of popular writing about this, and it's very, very difficult to do without assuming or explaining the doctrinal presuppositions. Modern campaign finance law goes back to 1976 in a case called Buckley versus Vallejo. And over the past 40 years, although there's been some wavering, there have been some relatively solid doctrinal foundations to which the court has adhered more or less consistently, but about which the court has been consistently divided. And so we're going to talk about a particular framework that the United States Supreme Court has established for us, but it's important to note that there are probably 4 justices on the current court, and have pretty consistently been a 4-justice minority, that does not buy into this framework at all. So here it is. Now, the first thing is, we said provocatively in our campaign finance report that money is speech. I think that in terms of understanding the law, the question of whether money is speech is sort of beside the point. The justices have fairly consistently, and now I'm talking about all of them, recognized that if you have laws which inhibit the way in which you can spend money to speak, that has constitutional implications, and some type of of heightened scrutiny is going to be necessary, because the First Amendment, I always say the First Amendment would sort of be an empty right if all it protected was your ability to stand in the corner and shout at the cars as they went by. So we start with that, and then the court has, and we can trace it back to Buckley, suggested that, and I think Matt will talk about this a little bit now, made clear, that the only basis for restricting speech is to prevent the actual or apparent quid pro quo corruption. That is, Congress and state legislators can decide that anti-bribery laws are not enough and that we can restrict what money people give to office holders in order to prevent the possibility that there's going to be quid pro quo, the policy is going to be traded for contributions. And when you decide, if you decide that that's the only thing that campaign finance law can be about, a number of things then follow. And so we go from Buckley, from the beginning, we see that the court treats expenditures differently than contributions. That is, if you decide to give money to a politician to speak, that is different, that's a contribution, and we'll have there's this different constitutional analysis that applies to that, as opposed to when you spend money to speak on your own. And Judge Sykes, who is looking, yes, there you are, looking down on us, she put it, I think, very succinctly. She said that limitations on contributions are usually sustained, and limitations on expenditures usually flunk. And that goes back to Buckley, and it's been pretty consistent with, some, little backfilling over the past 40 years. However, the court has also recognized there's a difference between independent expenditures and expenditures that are somehow coordinated with a candidate. Right? We're going to talk a little bit about that, and we know that this is the topic of one of the subjects in the John Doe investigation, the idea being that if you make an independent expenditure as opposed to giving money to a politician, it's less likely to lead to a debt of gratitude. It's less likely to be the basis for some type of quid pro quo transaction. But if your expenditure is coordinated in some way with the candidate, or the candidate has asked for it, then the specter of quid pro quo corruption comes back into play. By the same token, the court has generally has suggested, although I would argue that this is now no longer part of the law, or not in any, well, I shouldn't say that, but is less significant than it used to be, that express advocacy can be treated differently than independent advocacy. Express advocacy, that speech which is somehow calling for the election or defeat of a candidate. Issue advocacy, that speech which is on issues. And that's a distinction that goes back to Buckley, where the court sort of, in an exercise of constitutional avoidance, construed the 1974 amendments to the federal campaign finance law not to apply to issue advocacy, and that's, of course, what led to all of these, grimy, sepia-toned ads which, tell you to call Senator Foghorn and tell him that, he should stop, voting to, I don't know, whatever, starve babies. That's issue advocacy, right? And the court in Buckley, and this is, again, something that comes back to us yet today, the court in Buckley suggested that at least for its purposes of statutory construction, that express advocacy required essentially magic words. Vote for, vote against, that type of thing. And so when we talk about the law in this area and the constitutional analysis, you have to sort of keep these doctrinal foundations in mind. What is the justification for restricting speech? Maybe it's just quid pro quo corruption, although there's other potential justifications, and maybe Matt will talk about those. There's a difference between expenditures and contributions. There may be a difference between coordinated and independent activities. There may be a difference between express and issue advocacy. And once you have these doctrinal foundations down, you understand what lawyers are talking about when they use these terms, then the conversation can proceed. Tell me why I'm wrong.
Starting from the top. The first principle you announced was money is speech, and I would posit that that statement on its own should be shelved along with separate but equal. There's no basis in the Constitution for the notion that speech is the equivalent of money. What money is a megaphone to amplify speech, and when you say money is speech and put them on the same par, all you're saying is persons with more money are entitled to more speech. And I don't think it's true. And I think that leads to a lot of what is now this jurisprudence, which is falling down on any attempts to actually put realistic regulations that will instill a sense of confidence in people across the country that politicians are not truly in the pockets of those with money, because that's the impression folks have right now. So that's part one where I think you're wrong. You're right.
I take it you're making now a normative argument. You're not suggesting that I describe the case law inaccurately.
You are absolutely right about the case law, and I'm saying the premise is incorrect. The second distinction, which you point out, which is true, is there's a sharp distinction, it's getting sharper by the day, between express advocacy and issue advocacy. And everybody says, well, what's issue advocacy? What's a phony issue ad? And really, if you step back, all issue advocacy is everything that doesn't meet whatever the current definition of express advocacy is. So it's almost, it doesn't have its own definition. And so when one turns to how to regulate things in this area that would survive a constitutional challenge, the problem is not dealing with issue advocacy. The problem is properly defining express advocacy in a way that gives the clear and bright lines between spending that's allowed, speech that's allowed, and speech that is not. And so a lot of the premise, people are looking at it the wrong way by focusing on the shady ads and the call your senator and tell them. That's simply because it doesn't rise to the level of what we've defined as express. So if you want to get forward and you want to have things that survive, you need to define what's express. And the best and easiest example of where Wisconsin hasn't gone is where the federal government has gone in electioneering, and where they've said, we are going to define electioneering speech and regulate it if it's within 60 days of a general, 30 days of a primary, it's mass media, and it mentions the name or has the image of a candidate. And they define it, and it's clear and it's acceptable. So that's really where the focus should be.
Well, I could argue with you about whether money is speech or not speech, but I know Alan and Brad are going to sort of perhaps, be more philosophical and expansive. And so let's focus on, where the law has moved in the last couple of years, because we've had some very significant developments in the Supreme Court, haven't we?
Yes, and one of the more recent ones, and I say recent only because McCutcheon put the dagger in the heart of any doubt about it, is that the only acceptable justification for regulating speech in the political arena is the actual or apparent quid pro quo corruption. Now, this language about preventing corruption goes back to Buckley and all these early cases. It ran through them. But there was never the clear and definite argument that the appearance of corruption versus quid pro quo corruption was a hard and fast line. And the Supreme Court last year made crystal clear that when you're regulating in this realm of contributions, the only thing that's going to stand up is when you're battling against the appearance or actual quid pro quo corruption. So, Rick, I give you $10, can I get an A? In the realm of
I charge
class.
more than that for an A.
I knew that's what happens. 1,000 for an A.
That's okay.
I'm going to keep going. And the other things that used to be there, the attempts to regulate before McCutcheon came down, some states had tried to limit the amount of spending allowed by candidates, saying we need to have an even playing field. Some states had floated systems where if independent spending came in large on one side, the other candidate would be allowed more spending to equal that kind of spending. Those kind of justifications for an even playing field are out. There's no quid pro quo consideration at all there. The problem I see with this framework is that it eliminates the appearance of corruption. And I would posit, looking at politics today, just writ large, and this is somewhat the result of Citizens United and other decisions that have come down, but a lot of the impression that a lot of the folks in this country have is the system is corrupt. It may not be quid pro quo. It may not be that somebody can go down and make a contribution to a super PAC of $100,000, then walk down to their senator's office and get a bill passed. It may not be that quid pro quo obvious. But the impression is, and the feeling is amongst a lot of the folks, is the system is corrupt. But the Supreme Court has said, as far as contributions, that appearance of corruption in and of itself, not sufficient to sustain any limitations.
Right. And that, of course, as you can imagine, and Matt points out, that that is a matter of some controversy, right? There are people who argue that, yeah, you ought to be able to regulate campaign finance in order to level the playing field. Or people like Larry Lessig, I think in particular, but a lot of academics will say, well, you need a broader sense of what corruption is, because the court, even the court's conception of quid pro quo corruption, say it fast 3 times, is very narrow, right? It has this sort of a sense of a transaction that's going on, and the court has actually explicitly disavowed the notion that you can regulate campaign spending in order, because the people that spend a lot of money will have more access to politicians, right? That if I give Scott Walker $10,000, he's more likely to take my call
Which
than
is
if
true.
I don't give him $10,000. And it is true. And the court has said, look, that's not enough. And I think that and there's a minority on the court, I think, that doesn't see it that way at all. They would allow broader justifications for the restriction of campaign financing, but they have never really, with a couple of exceptions, right? A couple of cases back in the 80s where they suggested that other justifications might warrant restrictions. They've not been able to maintain a majority, and so that's the law. And I think it's predicated in a belief on the part of the majority of the court that they're very distrustful of allowing politicians to tinker with the rules by which elections that decide whether or not they get to keep their jobs or not are run, right? They're very distrustful. They say that politicians really are the last people that ought to be making these rules. Now, if you, as I said earlier, if you accept this proposition, right, you got to have quid pro quo corruption as a justification, then certain things follow. And one of the things that follows is that maybe you're not concerned about issue advocacy. And because the reasoning is that issue advocacy is less likely to lead to this debt of gratitude, less likely to be the basis for a corrupt transaction, because it's not discussion about candidates, it's discussion about issues. Now, of course, that's not necessarily so. Certainly discussion which is couched in a certain way during an election can favor one candidate or favor another. But I think there's another reason that the court has extended robust protection to issue advocacy, and that is it realizes that there's no judicially manageable stopping point. You have to let people discuss issues. You've got to. And so to say that, well, they don't really care about the issue, they really are trying to influence the election, would be to significantly water down First Amendment protection for people who want to engage in conversation about matters of interest to the public, particularly at a time when the public tends to be listening most, and that is during election season. And so sort of an interesting couple of things happened in the last 10 years. Matt referred to McConnell, right? The McCain-Feingold amendments that were passed in, I think, 2001 took aim at these so-called phony issue ads and said that, if you run an ad which mentions a candidate for federal office during a period immediately proximate to the election, that ad, it has to be paid for with hard money, right? With money which has been raised and reported in accordance with the campaign finance regulations. And in McConnell versus FEC, the Supreme Court upheld a facial challenge to the McCain-Feingold, said that's constitutional. A couple of years later, 4 actually, an as-applied challenge comes up to the court in a case called Wisconsin Right to Life versus FEC. And Wisconsin Right to Life versus FEC involved some ads in which Wisconsin Right to Life wanted to run these ads when Russ Feingold was on the ballot. And what the ads were, what would happen in the ads is you'd see this couple and they would go up and they were getting married, and the priest or the minister would say, if anyone, who presents this woman to be married? And the father would say, I do. But first, I'd like to give you some hints about drywalling. And he starts to talk to the congregation about drywalling. And this was supposed to be an attack on judicial filibusters, right, where you're not allowing a vote on judges. And then, the ad would come up and it would call Senator Feingold and tell him that, judicial nominees require a vote. And so the question is, could Congress constitutionally limit the funding for that to hard money? And the Supreme Court said no, because issue advocacy has greater constitutional protection, and moreover, it defined issue advocacy in a way in which you would have to be a fool not to be able to couch your message as issue advocacy. The court in Wisconsin Right to Life said, we call it Wisconsin Right to Life 2 because there was a preceding
It's because
question.
Wisconsin Right to Life has brought every single case challenging every single law, so we've got to put numbers on it.
They really have. I think they do more campaign finance there than anything else. So what the court said in this case is that something is issue advocacy unless it is susceptible of no other reasonable interpretation other than as a call to elect or defeat a candidate. Think about that. That's a very, very broad definition. But the court doubled down on that. It said, and we don't want any kind of extensive contextual inquiry into whether or not something can be interpreted that way. That determination really has to be made on the face of the communication itself. And I would argue there was on strong First Amendment grounds in doing that, because basically it was saying, look, you got to have clarity in this area. But you got to know whether what you're doing is an issue ad or an express ad. And so we're going to draw a bright line, and you don't have to worry that somebody is going to try to prove that you really intended to do something else. The court made clear that it doesn't matter what motivation is, doesn't matter what effect is, unless it is susceptible of no interpretation other than a call to elect or defeat a candidate, it's issue advocacy. And although it may be, and we'll talk about this later, that there could be disclosure requirements, you can't restrict what can be contributed or how it can be contributed for issue advocacy. And I think that was, in my view, that was an extremely significant decision. In fact, I would argue that is the most significant campaign finance decision in the last 15 years. Everybody talks about Citizens United. Wisconsin Right to Life 2, that was the case. Right? That was the case that I think changed everything. Incidentally, the court, so Chief Justice Roberts and Justice Alito said in their decision in Wisconsin Right to Life 2 that they were not overruling McConnell. Every other justice on the court said, yes, you are, you're overruling McConnell. And I remember after Wisconsin Right to Life 2, talking, I think, at Constitution Day here at Marquette Law School, and I remember saying, look, if you have, what was it at the time? Ruth Bader Ginsburg, Souter, Breyer, Thomas, Scalia, I can't remember who else was on the court, all agreeing on a proposition of law. It is a rule of science, of physics and chemistry, that what they're saying is probably true, right? Because if you can get all those people to agree, it's got to be right, right? But that's Wisconsin Right to Life 2 is the law, and that has been significant with respect to our rule here in Wisconsin, because in Wisconsin, if you look at Chapter 11 turns on whether or not something is done for a political purpose. And political purpose is described in the statute as something that is done with the intent of influencing an election. After Wisconsin Right to Life 2, I would submit it is absolutely clear, not debatable, that definition is unconstitutional. It is unconstitutionally vague. It is unconstitutionally overbroad. The GAB has kind of sometimes sort of recognized that, and sometimes not recognized that in various ways. In Barlin 2, right, one of the decisions in Wisconsin, we call it Barlin 2 because there was a preceding decision in the Barlin case, which is also very significant. The Seventh Circuit made clear that indeed is the implication of Wisconsin Right to Life 2. That definition of political purpose, upon which virtually the entire Wisconsin regulatory structure turns, is unconstitutional. And in order to avoid invalidating Chapter 11 in its entirety, almost, it adopted a limiting construction and said that in order to be done for a political purpose, something must be done as express advocacy. In other words, it incorporated the Wisconsin Right to Life 2 definition, said if it is susceptible, if the communication or whatever it is we're talking about is susceptible of some reasonable interpretation other than something done to elect or defeat a candidate, then it's not done for a political purpose within the meaning of the statute and therefore would be outside of Chapter 11. And now whether that applies to coordinated activities is something we'll talk about in a moment.
Well, let me start with a little bit on issue advocacy. And I don't know how many of you have been driving around, like me, listening to NPR in the morning, and you would have heard, you missed it. Well, they've been going heavy with some ads in support of right to work, and it's with someone with the nastiest sounding voice telling me I need to support this, and it's almost a caricature of an issue ad. And one of the problems I have with the term issue advocacy is it gets conflated by those who like to pump it up as if it has to do with issues and not affecting elections or affecting politics. It most certainly, a lot of times, is designed to move votes one way or the other. And sometimes it will use an issue. In fact, it always uses an issue. Everything, when you're talking about someone, is an issue. But the term issue advocacy, I think, gets put on too lofty a perch when all it is something that is too nebulous to be regulated because we can't get our arms around it in a constitutional fashion. It's really just non-express advocacy. I was sitting in the Wisconsin Supreme Court in 1999, minding my own business, watching some arguments, and the WMC case was being argued. And this is Brady Williamson of Godfrey & Kahn arguing on behalf of WMC and WMC IMC. And it was an issue advocacy case, and the Elections Board had found that these issue ads were actually express advocacy trying to impact an election. Now, I remember to this day Brady Williamson's great argument. Absolutely, we were trying to impact the election. There's no doubt about it. We admit it. We're open about it. But we did not use express advocacy, and that's the standard. And I was blown back, and it took me a while to realize the brilliance of that argument, because his point was, and this was years before I could get my thinking around that, is the intent didn't matter. because you're talking about a first principle, a First Amendment, and we are not going to have courts delving into what the intent was. So he was open about it, and he got blistered by a lot of the court, but in the end they said, you know, that maybe that's something that can be regulated, but currently Chapter 11 doesn't. There's nothing in there that would give guidance to somebody about whether that was speech that should be regulated or not. And they threw the case out on due process grounds rather than having the courage to reach the constitutional issue. But it opened my eyes that, wow, okay, so really what we're talking about is just trying to get the right bright line. And once you have it, you can try to impact politics and elections all you want as long as you're not on that bright line. And we'll call it issue advocacy, call it non-express, call it what you want. You can do it. And that has led, in my view, to a lot of cynicism about the entire system, because when we are driving around and we hear these ads about right to work, we know exactly what's going on. The voice of the announcer tells us what's going on. I don't need Brady Williamson telling me anymore what's going on. And there's some cynicism in that. Now, on the other hand, and this is for my friends on the left, and I've represented unions in the past and whatnot, and it does get through to some of them that, okay, let's put the disgust over in the corner and let's walk back and consider what we're talking about, and we're talking about speech. At the end of the day, it's ideas and arguments that are being conveyed to the public that are trying to help someone reach an opinion. And that's not necessarily a negative thing. And the answer should be fight it with more speech. So that's really, you can argue all you want. It's clear the way the law is going, and Rick will tell you, and he's right, it's just downhill. We know where things are going. But at least on both sides, if you sit back and say, at the end of the day, you're just hearing more speech about politics, there is some good in that. And if people can just accept it and get on board, it's probably best moving forward. But I do think this entire issue advocacy, express advocacy schism has deepened the cynicism of the public about politics and speech.
Yeah, and incidentally, I don't disagree that issue ads are designed to influence elections. I just don't care, in the sense that I don't think that I can't conceive of a set of rules that would provide adequate protection for freedom of speech that didn't essentially say, look, you can talk about issues. One of the things that happened, and now I'm now sort of departing a little bit from our structure, but and jumping ahead. But I remember when Citizens United was being argued, and Citizens United involved express advocacy, or at least you could make a pretty good argument that it was express advocacy because it was about this thing called Hillary the movie. And in my election law class, I show...
You've all seen it, right? Hillary, everybody's seen that?
Well, in my election, you haven't seen it, but in my election law class, I show students the trailer for Hillary the movie. And it's quite clear that the people who made that movie, well, they do not like Hillary Clinton at all. And that the communication was really about Hillary Clinton as a person, right? And so it was easier to say it was express advocacy. And so in the course of the oral argument, one of the justices asked the lawyer for the FEC. He said, lawyers say you usually can't win or lose a case in an oral argument. Well, here's the counterexample. They asked the lawyer for the FEC, well, if what you're saying is right, that Congress can regulate or Congress can prevent corporations from spending money on a communication that names a candidate for federal office right before an election, then Congress could ban a book. They could tell an incorporated book publisher, which is like all of them, that you can't publish a book that talks about a presidential candidate in October of a presidential election year. And the lawyer for the FEC said, well, yeah, but they haven't. And at that point, I think it was one of those rare moments in oral argument where, the there were, a good number of the justices sort of had this "you got to be kidding me" look on their face, and they rescheduled. They held the case over for additional argument. But I thought that Citizens United was lost. If it wasn't lost before, it was lost at that moment, because there's no way that the Supreme Court was going to adopt a rule, I think, that justifies book banning. And so the court, that I think led to the court ultimately concluding that the legal form of the speaker doesn't matter. Personally, I don't think Citizens United was as significant a case, that aspect of Citizens United was as significant as another aspect which is less remarked upon. And because I think that, there's been a lot of focus on, commercial for-profit corporations now using their massed wealth to speak. We haven't really seen that happen, right? That's not exactly what happens. I also showed my election law class this really funny segment from the Jon Stewart show after Citizens United, where they're talking about, this is a wonderful day because corporations have now, for the first time, had their rights recognized, and they're talking about the Million Logo March and all this kind of stuff. It's really pretty well done, but it doesn't happen that way. But really, the corporations that speak tend to be corporations that are formed for the purpose of some type of advocacy. Although it does open the door for corporate contributions. I think that the more significant part of Citizens United was how it treated independent express advocacy. How about that?
I think the more significant part of Citizens United is the extent, the deep, abiding, incredible extent that it has deepened the cynicism and hopelessness of people of believing that they can impact a system, that they and their neighbors can impact a system. When the Supreme Court comes down and says, hey, corporations are people too, right? We all know they're legal persons, but political speech, it was a thunderclap moment for the public. And this one really just resonated hard, and it makes you feel you will never make a difference as long as these gigantic corporations can go spend. Now, do they? There's not great evidence that the GMs of the world have gone out and spent massively on campaign ads, at least in their own name. But is there a sense that there is high-level corporate amassed money that moves around and funds a lot of what we hear? Yeah, there's a sense of that. Is there a sense that that came from Citizens United? Yeah, there's a sense of that. And is that sense that the system is rigged for all of us, against all of us, is that a problem? Yes, that's a problem. Right now, though, that problem is not moving a hair in the United States Supreme Court. So that's where we are today. And I think that's, even though you're right on practical grounds, there may be other parts of Citizens United and Wisconsin Right to Life 14 that have a bigger impact. But the real impact of that was on public perception.
Yeah.
Can you give us a sense of where we are on contribution limits and disclosure rules in Wisconsin?
That's Joe's polite way of saying we're using up our time. And let me just go back then on contribution limits. What McCutcheon actually held is that aggregate limits, meaning a limit on the total amount that a person can contribute to all candidates or all PACs, is unconstitutional. So it means the really, really rich can give a really, really big amount to as many people as they want. And what happened then is Wisconsin, we had a limit in Chapter 11 of flat $10,000 in any calendar year was the most you could give to anybody. So if you maxed out to a gubernatorial campaign, that's it. You couldn't give a penny to anybody else. That's gone. What's next, I posit, and there's a lot of this that is going on, at least Justice Thomas brings it up in every one of his opinions, and I think it's gaining momentum. The next attack is going to be on individual contribution limits, which in Wisconsin have been set at the same levels essentially since about 1973. It's $500 for an assembly candidate. It's ridiculous. So the next challenge I think that will roll down successfully will be to individual contribution limits.
And let me sort of pull that together and respond to Joe's question, and in a way that allows me to say what I was going to say, and also respond to what he wanted me to say. In Citizens United, the Supreme Court said, well, you can't regulate the expenditures. You also made clear that you couldn't regulate expenditures for independent express advocacy, because if it was independent, you wouldn't run the risk of quid pro quo corruption. And so, as Matt points out, now we have a system where basically you can contribute whatever you want for either issue advocacy or express advocacy, as long as the express advocacy is independent, right? And these are the so-called super PACs, right? And so this has and I think if you look at campaign finance regulation, the one constant theme that it runs through it is that it is replete with unintended consequences, because money in politics is like water. It seeks its own level, and you can't keep it out. Somebody once said that the history of campaign finance regulation is like playing a game of whack-a-mole with an endless supply of moles, right? Money will always find a way. And so what's happened now is, and this is particularly true in judicial elections where it's hard for candidates to raise money, is that money flows to independent spenders, because you still have these campaign contribution limits in place. Remember what Judge Sykes said, campaign limits usually win, or contribution limits usually win, and they're very, very low, and so you max out very quickly, right? There's been some cases which have sort of expanded the ability of people to make contributions. McCutcheon struck down aggregate contribution limits on the federal level. We filed a case on behalf of Fred Young that struck them down on the state level. We filed a case on behalf of CRG that eliminated aggregate PAC limits to candidates.
When he says we, he's not talking he and I.
No.
Just to be clear.
No, I'm talking about the Wisconsin Institute for Law and Liberty, a 501c3 organization to which deductions are tax deductible. And so there's an argument to be made that maybe we should revisit these contribution limits, because what we've got now is essentially distorting the messaging in political campaigns. That messaging is owned by independents. It is not owned by candidates. And the most extreme example of this is in judicial elections, where it's very, very hard for somebody who's running for judge to raise money. The maximum limit for a statewide race is $10,000. Now, $10,000 is more than I certainly have ever given a candidate, and than most of us will ever give a candidate. But when you got to run a statewide race, you've got to get a lot of contributions of $10,000 or smaller in order to, actually make noise. And so in judicial elections, statewide Supreme Court races, it's really hard for the candidates to make noise, but it's not hard for the independents to make noise. And so, so some people argue that, look, what we've really done is that we've created a system that, because we want to respect the First Amendment, is basically distorted the messaging in political campaigns. And some people will argue that what we ought to do is we ought to get rid of contribution limits, and we should and that we should focus on disclosure.
And here is an area where Rick and I agree, and that is the result of this cavalcade of constitutional law pushing money to this independent spending and away from candidates and keeping the individual limits for candidates in place and throwing everything out. The message is being controlled by the people who aren't running for office, but the people who want to have impact on them. And I, at least, am all for trying to flip that table a little bit, because one of the things about a campaign contribution made directly to a candidate is it's reported. We know about it. You can't give more than $50 in cash. When you give at least $100, not only your name is reported, but your employer's reported. And all that is public knowledge, all of it, every penny. And so if, in fact, in our next round of Chapter 11, heck, they might as well just make it a new chapter, Chapter 1010, because Chapter 11 has such a bad name to it. But if in that new statute, they say no limits, no limits, give all you want, you're not going to see what you think, which is just obscene giving, because it's public, it's known. It will ferret out that quid pro quo corruption by the very fact that what people are giving is known. Now, one of the fights going on the edge of things is, to what extent can we regulate disclosure of this outside spending? And one of the funny things that people don't remember about Citizens United, what I think is another good part about it, is by a vote of 8-1, the court held that disclosure rules were completely constitutional, completely. And going forward, one of the avenues to try to get some integrity back in the system and trust in the public will be to push not only contributions back to the candidates who should control their own message and who have to disclose them, but to have better disclosure requirements on the independent spending.
Yeah, and we probably should leave it time for question, but I would just raise one little thing. The Citizens United Court reserved the issue of what would happen if, in an as-applied challenge, if you could show that state-compelled disclosure would lead to harassment. Because disclosure, if you think about it, it is a burden on speech. It will dissuade some people from speaking, from associating, from giving money, because they don't want their name to come out. And there is, well, I have a long and proud legacy of case law on my side, because, if you go back to the 1950s, Alabama had a real cool idea. It said, here's what we're going to do. We're going to make voluntary organizations, like, say, the NAACP, disclose their membership and their contributor lists. Now, if you had given money to the NAACP in Alabama in 1958 and the state made you that be made public, what do you suppose was going to happen to you? And so I always tell my friends, particularly in sort of the wake of all the controversy that we've had in Wisconsin, if you like disclosure requirements, stop calling for boycotts, right? Stop shaming people. Stop doing all of that, because to the extent that you do that, you create constitutional problems.
Yeah. Anybody has any questions? I think, you're supposed to hit your little bubble?
You hit the rim of the...
Oh, that's, red light goes on. So.
We have time for questions.
There we go.
They weren't that good. There are things left to be said. Can you, yes, please, hold the rim down. Thank you.
Connecticut has done two things, starting in 05, 06, when they still had a Republican governor, by the way, Judy Rydell. One is outside contributions are limited to 15%. 85% of the contributions have to come from a resident of Connecticut. And the other one is, and you were talking about cash, any contributions more than $99 must be by check or credit card. So if I gave you $990, you couldn't break it up into 10 less than $100 contribution and just bundle it and not have to do the disclosure. Why aren't more states doing little things like that would help the situation, especially Wisconsin?
I think they're not doing the first. That is, they're not passing laws which prohibit or limit the ability of people who live outside the state to contribute to candidates within the state, because it's probably unconstitutional. I don't. There have been some court.
It was passed in 2009 by the Constitution.
Well, no, it wasn't. There are cases. I am not sure. I know that there are lower court cases which strike it down. I don't know whether there are lower court cases that support it. I don't think we have Supreme Court guidance on that.
Well, we are in Wisconsin. We do have a hard rule that you can't give more than $50 in cash. Anything above that has to be by a negotiable instrument, a check or credit card or anything like that. So we are on that. Wisconsin has a system in place for candidates where there is limits on the total amount you can accept from individuals versus the total amount from PACs, and it's a 65-45 rule. All of those kind of rules really
we got a temporary injunction against that.
Yeah, okay. See, they're hanging by a thread or they're done. In light of where the case law is going is when you try to monkey with the amount and make measurements and make anything based on anything other than quid pro quo corruption, you're out.
Other questions? Yes. Can you stand up and speak into the microphone that Ryan's giving you? Thank you.
Thank you both so much for coming today. My question has to do with the oral arguments in Citizens United. I think you made reference to the advocate for the FEC who was asked about whether Congress had the ability to ban a book. And I don't know if that was exactly a fair question to whichever justice posed that, because the question should have been, does Congress have the right to ban soft money to be spent to publish that book? You know, I think that it was kind of showing an underlying attitude that money and speech are directly connected.
But you effectively are. If I tell Simon and Schuster that you can't spend corporate treasury funds to publish a biography of Barack Obama in October of 2012, I am effectively banning that book, right? Because it's not going to get, you can't publish a book without spending money on it. Now, some people will argue that, well, we can make an exception for media corporations. I don't know how you define what a media corporation is or what conceivably could be the constitutional basis for doing that. As Justice Scalia says, in the late 18th century, when the First Amendment was passed, there weren't a lot of guys running around with press cards sticking out of the band of their fedora. This was a constitutional guarantee that applied to everybody and not a privileged caste.
I will say, I think the question was an unfair question. It was a setup question. The Austin decision that said corporations can't spend money on politics was sound. It was good public policy. It was consistent with the First Amendment. And I think the court went into that argument, or at least part of the court, with the goal of getting to a particular point. And that's why the additional briefing was ordered, and that's why they reached an issue that, gosh, the parties to the case never thought to raise themselves, which is that corporations need to be viewed as people who can spend political money.
Other questions? I saw another hand or two up. Yes, can you, please?
Sure. So to your last point about the disclosure rules and how that would have affected speech in the 1950s, so what really is the case is that if we have better disclosure rules, that will reveal to the state and other governments what true protection needs to be given to real people who want to speak out.
Right. I mean, so there have been some Citizen United cases in which people have attempted to argue that disclosure requirements were resulting in levels of harassment that required them to be protected so that they shouldn't have to disclose. And generally, those cases have arisen.
Don't have to disclose, but that the state will come around with adequate protection.
Well, yeah, I mean, you know, how does that work? What I'm trying to do, what I'm trying to do is describe the case law. Those cases have arisen usually in the context of people who spent money opposing same-sex marriage, and then there would be some type of, they would say that they'd been retaliated against in some way. Those cases have generally, those arguments have generally not been successful, right? Plaintiffs who have made those arguments have generally not been able to convince the lower courts that whatever retaliation that they were subject to was sufficiently severe to create a constitutional problem. That's where the law is now.
Doe versus Reed, right? And that's, you're right. I mean, disclosure is one of the ways to try to get our arms around and get some more integrity and trust back into the system.
I think
is
we have
put
time,
it out there. Have the courage of
one
your
more
convictions.
question, very quickly.
Very briefly, can you just touch on a little bit the coordination issue between the advocacy groups and candidates?
Right. So
you have 1 minute in which to do it.
all right, so the Supreme Court said in Buckley, it suggested that if you have coordinated expenditures, then perhaps you have this risk of quid pro quo corruption. And so a state can limit treat coordinated expenditures basically as a campaign contribution, and that's the theory of the dough, that these expenditures, they would have been independent, they would have been unregulated, but because they were coordinated, they should have been reported as a campaign contribution. The problem is that we have no constitutional definition of what constitutes coordination, and I would say that we have clearly an insufficient statutory definition. I don't even think we have a clear prohibition of coordination as it applies to issue advocacy in Wisconsin statutes, and we clearly don't have an adequate definition of the conduct and the content of communications that can be considered coordinated.
We're going to give
And
Matt
I'll
the
give
last
you
word.
my 5 seconds on what the issue right now that's pending before the Wisconsin Supreme Court in the John Doe cases has to do with whether Wisconsin has or can regulate coordinated issue advocacy. So if an outside group is running a non-express ad and they coordinate it with a candidate, number one, is that prohibited? If so, is it constitutional? The number one question is difficult. There's a 1999 Wisconsin Court of Appeals case that says you can't do that. That's illegal. And then there's Barland 2 that came down with the Seventh Circuit saying baloney. That's unconstitutional. And there's a statutory argument that says Wisconsin hasn't done it. You look at Chapter 11, you will find nothing in there that you can add up to coordinating this non-regulated message with the candidate makes it a contribution. That's an interpretation. And when you get to the question of whether you can, it's going to lose. So assume that the result of that case is going to be a finding that the statutes don't reach it, and if they did, it would be unconstitutional.
And an agreement.
We end in agreement. Well played. Thank you very much. We will reassemble at 9:30. Okay, thank you very much. And certainly my thanks to Rick Essenberg and to Matt O'Neill. This session of the half-day conference gets at, or perhaps I should say gets more at, the should-be part of the title, the law as it should be. Now, for those of you who know Marquette Law School, such a characterization might surprise you a bit. The law school scrupulously avoids taking positions on just about all matters of public policy. We're in favor of the diploma privilege. To be sure, some of my faculty colleagues may urge particular views of law or policy, and entirely appropriately, but we regard the role of the law school itself as instead to do such things as to convene people for civil and intelligent discussion. Often this discussion is led by individuals who have some longtime connection with the law school, as with Rick Essenberg and Matt O'Neill on the last panel, or as with my colleague Mike Goucher on the third panel. But often, too, this discussion involves our effort by the law school or those with whom we partner, such as the Federalist Society and the American Constitution Society, to bring to Milwaukee individuals with expertise from elsewhere. So when we gathered to organize this conference, we wanted to have a panel involving national experts in campaign finance and First Amendment law. And not just that, but individuals who were quite willing to discuss first principles, at least the law as it ought to be, in their estimation, with the First Amendment properly interpreted by their various lights. It was not difficult at all to agree quickly on whom we wanted somehow to get. One, and the individual closer to me at the moment, is Alan Morrison. Alan Morrison is the Lerner Family Associate Dean at George Washington University Law School. To say this is not even to begin to hint at his expertise and renown. Over the past more than 40 years, Mr. Morrison has argued some 20 cases in the United States Supreme Court, many of them on behalf of the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1971. He is a past president of the American Academy of Appellate Lawyers, where, for a point of personal privilege, I will note that he collaborated with my friend and predecessor, the late Dean Howard B. Eisenberg. He also has taught law courses over the years at Harvard and Stanford, among other places. No less impressive is his fellow panelist, Brad Smith. He currently holds a visiting chair at the West Virginia University College of Law and also holds the Josiah H. Blackmore II Shirley M. Null Professorship at Capital University Law School. Professor Smith is a widely published academic on campaign finance law and the First Amendment. Mr. Smith also went to Washington, where he served as a commissioner on the Federal Election Commission, or FEC, from 2000 to 2005, including service as chair of the commission. Today, in addition to his academic work, he is also the chairman and founder of the Center for Competitive Politics, a legal organization focused on First Amendment political rights. So we were delighted when, on short notice, we persuaded Alan Morrison and Brad Smith to join us this morning for an exchange of views concerning campaign finance law as it should be. Our basic approach is to give first Professor Smith 10 minutes and then Professor Morrison 10 minutes. That's consecutively, not simultaneously. And then another 5 or 6 minutes each. And then after the conclusion of that half hour or so, I will come back up here for the purpose of recognizing some of you for questions, which I will not at all answer myself, but redirect very quickly to one or both of Mr. Morrison and Mr. Smith. So please join me in welcoming to Milwaukee Brad Smith and Alan Morrison.
Okay, well, thank you, Dean Carney, for that introduction, and thank you all for coming, and it's a pleasure to be here. It's a pleasure to be here with Alan. When you do this, when you get, as the Dean so generously said, a national reputation, you get to go around and do these. It's kind of like a dog and pony show, but actually, Alan and I haven't done this since, I think, about 15 years ago at an event at Harvard, years and years ago, and I've always admired Alan for his brilliance, frankly, and for his moderation, and for his nuance, and so it's a pleasure to be up here to have this little discussion today. I'm going to suggest that when we talk about what the law should be a system that is lightly regulated or indeed no regulation at all. I want to begin by talking a little bit about some letters that I used to get when I was at the FEC. We would get letters from people who would write in. Typically, these were people who could not afford to hire an attorney. They were volunteers, citizens who simply wanted to be involved in politics. I'm going to read you just a couple excerpts. I have this big folder of these at home. I don't know if it was legal for me to take these copies out of the FEC or not, but nobody's ever come after me for it. This was from a CPA who was a volunteer campaign treasurer. You would think a CPA would be a guy who could handle being a volunteer campaign treasurer. He was facing over $7,000 in fines from the FEC. He was personally liable for these fines due to errors he'd made as the treasurer. And as he wrote to us, he said, "No job I have ever undertaken caused me more stress than this one. I was frightened and concerned every day that I would do something wrong." Another volunteer wrote, "We were just honest, hard-working, tax-paying Americans who wanted to make a difference. At this point," meaning after engaging with the Federal Election Commission for many months for their many violations of the law, he said, "We are so disillusioned with the legal difficulty of running for office that we wonder why anyone other than a professional would ever attempt to do so." A retired high school teacher, history teacher, wrote, "I taught and believed that we have the best government in the world. I was happy to be part of that process. I made every attempt to comply with the law, and now I'm being fined $600 for a misunderstanding." And as one volunteer summed up in big all caps at the end of her letter, "I will never, ever be involved in a political campaign again." Right? These are not isolated cases. This is your campaign finance law in action. This is what it does. These are the people who are affected. One study of 255 people, they were asked to fill out the mandatory forms that would be required to engage in political activity in different states. 255 people. And they were paid to get this right. The more they got right, the more they got paid. So they had an incentive to get it right. Every single person failed. Every single one. Had these people actually been volunteering for a campaign, they would have faced fines and jail time. In the last election cycle, some of you may have read Larry Lessig, who's a very brilliant, intelligent professor at Harvard, started a PAC called Mayday PAC. And the purpose of his PAC was going to be to convince people that we shouldn't be allowed to have PACs, essentially, super PACs, force them out of business, right? They raised millions of dollars. They were advised, their legal counsel was another former chairman of the FEC. They get lots of money from big entrepreneurs in Silicon Valley and stuff like that, right? We recently, my group, the Center for Competitive Politics, filed a complaint with the Federal Election Commission alleging literally dozens of violations of campaign finance laws by Mayday PAC, and noting that most of these were probably unintentional, but that showed the complexity and difficulty of the law, that this Harvard professor with a lot of money and the top legal talent was in fact unable to comply with the law. The current federal laws and regulations, this is just federal, we're not talking Wisconsin here, are over 376,000 words long. That's just the laws and regulations. That doesn't include all the advisory opinions and the enforcement matters and so on that one could study. At 376,000 words, it's about 75% longer than Plato's Republic. Now, personally, I'm not really a big fan of the normative values of Plato's Republic, but that's sort of the philosophy test that is supposed to raise all of the major issues about governance. And it does it in about 1/4 the length of our campaign finance laws. In Buckley v. Vallejo, the Supreme Court noted that, quote, the First Amendment affords the broadest protection to political expression. It noted that a First Amendment was fashioned, this is from Roth versus U.S., the First Amendment is fashioned to assure unfettered exchange of ideas. Again, in Buckley, the fullest and most urgent application of the First Amendment is precisely to the conduct of campaigns for political office. I want to suggest to you that these statements, first, are true, and that, second, they are incompatible with heavy regulation of political campaigns, including campaign finance. Now, we're not going to have time for me here to go deep into the woods on this, but let me just throw out then some observations. First, we often forget that prior to 1974, there were essentially at the federal level, and I can't think of any if there were maybe a handful at the states, but there were no limits at all on individual giving in political campaigns. In other words, the history of our nation is not one of trying to limit spending or contributions in political campaigns. The history of our nation is actually quite the opposite, right? It's one of very little regulation. Indeed, prior to 1974, there was not even any effective disclosure. We talked about disclosure a bit in the last panel. There was essentially no disclosure. There were a few laws on the books, but they were unenforceable and meaningless in terms of how the disclosure had to be done. Under this deregulated system, you know, let's get all patriotic. We became the greatest power, the wealthiest nation on earth. We beat the Nazis. We built the American middle class. We passed the Voting Rights Act. We passed Medicare by bipartisan majorities. We sent a man to the moon. Congress seemed to work in those days. People were proud of their government. They thought things were actually going pretty well, didn't they? And then we passed the Federal Election Campaign Act. Now, I don't mean to suggest that all of these complaints come from the Federal Election Campaign Act, right?
Just most of them.
Just most of them. It's worth remembering, by the way, the very first prosecution brought under the Federal Election Campaign Act was brought by the Nixon administration against a bunch of people essentially like us here, you know, sort of the best people, right? Upper middle class folks who had banded together and taken out an ad in the New York Times urging the impeachment of Richard Nixon, not for Watergate, this was pre-Watergate, for the invasion of Cambodia, right? And the Nixon administration said, well, this goes to this issue ad question of the last week. If they're urging people to impeach me, support my impeachment, that they might actually conclude they should vote against me in a year. We should prosecute those people. They're an unregistered political group. Again, that's what campaign finance laws are. But since FECA passed, since the Federal Election Campaign Act passed, note all of the trends. I didn't bring the PowerPoint here. I really am a Luddite, and I told Dean Carney I wouldn't come if I had to use PowerPoint, but probably I should use PowerPoint for this and put like catchy graphs up. So just trust me. I look like an honest guy, right? Just trust me. Since 1974, when the current law, federal law, basically took shape legislatively, turnout in American elections is down. Trust in government and confidence in government are down. The perception of corruption in government is up. Incumbent spending advantages are up. They've gone from about 1.5 to 1 to about 4 to 1, by which incumbents outspend challengers. The incumbent re-election rate has gone up. In other words, the system is generally much less fluid. We still have scandal. We have scandals regularly and all the time. I think few of you would want to argue that our campaigns now have a much higher tone to them than they did back in the 60s, that now they're really focused on issues, whereas before they were just talking nonsense. And I would suggest that we are not better governed, that the real test of regulation of campaigns and elections is, are we better governed? Does our government work better? And I think the answer to that is no. Today, there are essentially about a dozen states that are still essentially unregulated at the state level, and these states, Oregon, Utah, Virginia, are almost consistently rated as among the best governed states in the country. There's no evidence that they suffer from greater corruption or gridlock than others. Many of them have been among our fastest growing economic states, states like Texas and so on. And in fact, the primary purpose of campaign finance laws over the past 40 years has been used by each side to attack their political opposition. That's mainly what we saw at the Federal Election Commission. We'd see lots of cases, and some of them were clear violations of the law, and some of them were clearly not violations of the law, and some of them were kind of close calls, but virtually none of them had anything to do with preventing corruption, and few of them had much to do with equality. So I would suggest to you today that what we really need to be thinking is to go back to first principles. We should have a system of minimal regulation, probably no limits or at least much higher limits on contributions, no limits on spending, very limited disclosure, if any, that goes at candidates and parties and not at citizens, right? It's aimed at candidates and parties so we can monitor officials rather than at citizens so that the government can monitor us. Right? We've got disclosure backwards. And I think that we should think of campaign finance laws much as we now think of bleeding as a medical treatment. Campaign finance reform is to political corruption as bleeding was to medical treatments. And it was popular for about 2,000 years. It was a common treatment, but it was based on a gross misdiagnosis of what ailed the patient and a cure that did far more damage than good. Thank you.
Thank you. Friends, faculty, students, lawyers, and interested citizens of Wisconsin, lend me your ears. I do not come to bury Buckley nor to praise him, but to do something in between. The evil that opinions do live long after they are filed. The good that they do is often interred at the moment of their filing and their citation in the U.S. reports. So let it be with Buckley. The noble Smith has told you that Buckley was flawed because it failed to remedy all the problems and eliminate all regulations. If it were so, it would be grievous fault, but it is not. The laws on contributions that Buckley allows are fair and just. So are the edicts regarding candidates' spending and the limits on what candidates can spend of their own money, although their rationales are deeply flawed. Noble Smith is an honorable man, but like Buckley itself, his flaw lies in the conclusions against independent expenditures and in the justifications that he and Buckley offer to sustain them. Let me explain now in my own words instead of trying to copy it from William Shakespeare. All right. So let's talk about contributions. The laws on contributions are that, generally speaking, the limits have been upheld. They were $1,000 in federal level in 1974. They were sustained. Congress finally got around in 2002 to raising the limits to $2,500. They're now indexed for inflation. I think the laws in Wisconsin for not indexing to inflation are subject to challenge. And there's no reason not to do something along that line. But within those things, those cases are going to be upheld and contribution limits are going to be all right. As far as the Supreme Court said no limits on the amount of campaign spending by candidates. And they said that because they thought that they had a First Amendment right to say as much as you want, spend as much as you want. I agree with the conclusion, but for a different reason. I get very worried, as Brad does as well, when Congress sets limits on what people can spend to run against them. The natural inclination is to limit the amount of money. Indeed, in 1974, the law was clear that Congress was not trying to prevent spending from going up. It was actually lowering spending. They had lowered the amount that could be spent in presidential races below what it had been before, with inflation going in the opposite direction. The same is true with the ban or the limits on self-funding by candidates. The people who are best able to challenge incumbents are people with a lot of money or access to money. And it's clear to me that the ban on self-funding beyond a certain amount of money was plainly intended to prevent challengers from going after incumbents, that is, the people who wrote the law. I don't have any problem with those conclusions, and indeed, the politics of it prevent candidates from spending an enormous amount of money because you have to raise the money after all. And if there are contribution limits on the front end, they're going to be effectively spending limits on the back end, unless you're very popular, in which case you probably ought to get elected. And as far as self-funded candidates are concerned, I think the record is pretty clear that they don't do very well. The people don't like it when you spend all of your own money as all of the campaign money. They rarely get elected, and if you get elected, it's not a harm to the public. Now, on independent expenditures, here's where I part company. I want to ask a question to the audience. Does anybody know what the amount of independent expenditure limitations were? No talking about coordination or anything like that. Independent expenditure limitations at the time of Buckley. Anybody know what the number was? $1,000. That is the same number as in the contribution limits, but actually it's half, because you could spend $1,000 in the primary as a contribution and $1,000 in the general election. That is insane. No sensible person could have thought that an independent expenditure was twice as dangerous as a contribution in terms of corruption or anything else. It's plain that that amount was put in there because the people who wrote the law did not like money being spent, and they wanted to keep it down. So what did the court do? It could have just simply said, no, $1,000 is too low. You can't do it. There's no justification for doing that. But what did it say? It said, everybody's got a First Amendment right to speak. You can spend as much money as you want because you're independent. Money, it's your own money. All you're doing is speaking, and none of the other justifications have anything to do with anything. It is, as Brad just quoted, an unfettered right. Well, my big problem is that that is simply not what our constitutional law and the First Amendment talks about in other cases. So let me give you 4 examples of cases. And by the way, I'm not talking here about Citizens United and corporations. We'll skip over that for now. Maybe we'll come back to it. But I want to talk just about principles about, do you have an absolute right to say anything you want without regard because it's in the First Amendment context. So the first case called O'Brien against the United States. Mr. O'Brien burned his draft card. He didn't burn his draft card and was not indicted for causing air pollution. He burned his draft card as a political protest against the war in Vietnam. Everybody recognized that this was a political speech, but the court said, no, there's an interest in keeping registration cards in your pocket at all times, and that interest outweighs your speech interest. Now, I think that decision is wrong in terms of the balance, but the important point for this is that something other than purely political speech was held to trump political speech, and Mr. O'Brien went to jail. Second case, and this one I worked on, is a case called Burson against Freeman. Tennessee has a law, very similar to laws in many other states, that prohibit individuals from campaigning within 100 feet of the entrance to a polling place. The campaign, and this was done, obviously, election-related, directly related to the candidates running for office. And the courts held that those laws were constitutional, even though nobody was harassing anybody, nobody was preventing anybody from getting in and out of the polling place. People were, one of the plaintiffs had a T-shirt with the name of the candidate on it, and she took off the T-shirt, which caused great consternation among the election officials who told her she couldn't do that. She couldn't do either of them. She couldn't put it on or take it off. The Supreme Court said, no, that law, even though could be not more purely a form of political speech than it was, is improper, that the state interest in controlling what goes on in or near the election had precedence. Third case is a case not involving politics, although there was an earlier case that did involve it. It's called Rock Against the War on Racism. And this is a case, typically cases, almost every municipality has them, banning sound trucks after certain times of night, certain decibels, and it doesn't matter whether it's political speech or whether you're doing a rock concert or whatever else it is. They say, no, politics are important, but they're not all important. And the court said, rightly I think, that there are other values like letting people sleep at night and having some peace and tranquility at home that justify limiting the First Amendment right of politicians, rock concerts, or anybody else that's going on. The last case, and this is the most recent one, it's directly related to politics, is a case called Blumen against the FEC. Part of the labyrinth of laws that Brad likes so much is a provision that prevents people who are not either U.S. citizens or resident aliens with green cards from making political contributions or independent expenditures. The two plaintiffs in this case were citizens of Canada and Israel. One was a doctor, the other was a lawyer. They came to the United States on 3-year work visas, and they wanted to make small contributions, one to the Republican Party and one to the Democratic Party. They were told that they could not do this because they were not U.S. citizens or not non-resident aliens, and they brought suit. And the Supreme Court said, the case decided by a 3-judge district court, went to the Supreme Court. Supreme Court summarily affirmed the decision that said, it's okay to stop you from speaking just because you're not a U.S. citizen. Now, I think that decision is wrong. I had helped the lawyers who worked on the case. But again, the principle is things other than speech sometimes trump speech. And that's what the court hasn't recognized. The difficulty, of course, is going to be is what legislature is going to write a law to challenge the rulings that go back as far as Buckley. And Buckley is the problem. It isn't what's happened recently. It's Buckley that's the problem. And I suspect that nothing is going to happen until we get a change in the composition of the court, until people start making arguments to talk about these other things that matter besides political speech. Very important, but sometimes it's not the only word. Thank you.
Okay. Well,
by the way, Brad was kind enough to say what a pleasure it is to be with me. I want to say this with him. I don't agree with a lot of things he says, but he always makes me think about it. How come I didn't think of that before? And so it's been a pleasure, as always, to be with him.
Well, thank you.
Yes, I'll take it out of my rebuttal time.
Come on, Martinez. All right. Well, let's. I'll try to actually not use the full 6, but I probably will go over it because I'm a law professor. So just as a point of clarification for those who are wondering, the $1,000 expenditure limit at issue in Buckley actually never took effect. It was part of the 1974 law. So just to sort of harmonize my saying that there was never any limit prior with the point that Alan makes, so that people are clear on how that worked. And I do agree with that. And, I would look at the examples that Alan poses, and I do think they can be separated, and some of them may just be wrong as well. You note that in O'Brien, for example, I think the court just got the balance wrong in O'Brien. But the limitation on speech, so to speak, in O'Brien was based on something that the court believed was unrelated to the speech. That is, it was just really important that you have this draft card in your wallet at all the times, right? So apparently if the police arrested you or something, they would know if they could draft you. I don't know what but that's the argument sort of that they made. It was not related to attempting to limit his speech or his message in any way, in the sense that the law wasn't. Maybe the prosecution was, but to the extent that had he just wanted to burn an imitation of his draft card, he could protest as much as he wanted and so on, he could do other things there. Secondly, a case like Burson, right? Burson's a case, this is, sometimes people will say, well, you can't just buy extra time in the Supreme Court, or, we have rules of order in Congress and so on. Those aren't good analogies to campaign finance, because there we are talking about limited fora, limited space, and so on. And it's much the same. The government, in carrying out elections, is acting in an administrative capacity in which there needs to be, some ability to say, we have to let people vote. We have to have some order there. Again, I said I don't think it really matters where that kind of line is drawn, as long as it's not drawn at within a mile or 2 miles of a polling place or something. It could be 100 yards, 50 yards, 200 yards. You could not have it at all, but I think that's a valid administrative decision, then again is not related to an effort to smother the speech. Sound trucks, much the same way, and Blumen's a kind of an interesting case. Again, I'm not sure that I agree with Blumen, but the argument in Blumen is a sophisticated argument, Judge Kavanaugh's opinion, essentially about the role of non-native citizens not being members of the community and so on. Again, I'm not sure it's right? We let non-resident permanent aliens can actually spend money. You just have to be a permanent resident, not merely a temporary long-term work visa. So Blumen may just be wrong as well. But again, in each of those cases, Blumen possibly the exception, but I think there's a theoretical construct for it. We're not talking about suppressing the speech as being integral to what the statute tries to do, right? Whereas with campaign finance laws, even though we say, well, we have another interest is preventing corruption, is promoting equality, but that is integral
to regulating the speech. That is the whole idea. We regulate the speech because it is speech, not because it causes some harm unrelated to the fact that it is speech. So I think that is something that I would say is the difference in those cases. But within that framework, I think if most people had sort of the moderation that Alan implies, and although we have some very different fundamental views on this, we actually end up on the same side of a surprising number of cases because, he says like $1,000 limit's way too low. I mean, what would be an independent, if the independent expenditure limit was $500,000 or something, a person like me, I might say, well, I don't think we should have that. But look, this isn't going to be a big point of political contention. Whether or not non-resident aliens can do this is not a big point of political contention. Campaign finance laws are always very popular in the abstract. You can do a poll. Do you think money is corrupting? Yes. Do you think we should regulate it? Yes. But when you actually do it, they become very unpopular. That's the kind of letters I suggest it's sent. People don't like it. That's why the government gets sued all the time on it. It wouldn't get sued on these things. I mean, it would, obviously, because these cases were brought, but this is not the main point of contention. And if we had that kind of moderate regime, that would be pretty much in tone with what I've suggested, a lightly regulated, if not totally deregulated system.
So a couple of points. As far as pre-1974 is concerned, just a couple small matters. Of course, since 1907, the federal law has prohibited corporations from making contributions. And in 1940, Congress passed two parts of a law. The follow-up to the Hatch Act, which had been passed the preceding year, applied the Hatch Act prohibitions to state employees who were on federal grants or contracts. As part of that, they included a ban on federal contractors making contributions. That's been in place since 1940. I have a case now in the D.C. Circuit challenging the constitutionality of that as applied to independent contractors who are individuals. Too much to go into now. And also, at the same time, that Congress passed a limit on spending in federal elections of $5,000. Most people don't know that. I discovered it when I was going through the statute. Of course, it was never enforced because there was no enforcement mechanism. It was entirely criminal. There was no reporting of any kind, and nobody ever enforced that law. So there were some pre-1974 laws, and there were, of course, some in the states, but not very many. The second thing I guess I want to mention, Brad said that these laws, that the prohibitions that I discussed in these other laws were integral to the law. I always get very worried when I see adjectives like integral come into the debate. I talk to my students in con law about adjudication by adjective and adverb. Words like directly or indirectly or attenuated, those are highly subjective words, and when you see those words, particularly when they're preceded by the word mere, you know that something is going on and somebody's trying to pull the wool over your eyes. So, I don't see how much more a political button that said Obama on it could be more integral to an election when you go there to the polling place, when your purpose is to convey a message to your fellow citizens who may know you but not know how you're going to vote, that you're voting for Obama. It seems to me that you can't answer that by calling it integral or not integral, and you can't do the same thing with any of the rest of them. It just doesn't help you very much. If I could read my writing, I'd figure out what else to say, but I can't do that, so let's go on with the questions.
Terrific. So we have a good deal of time for questions, and we were over here earlier, so maybe we can go more to this side of the room. Was that? Yes.
Ours doesn't.
Okay, we will repeat the question once you say it then.
Okay, I would like to hear both of your views on how you think a constitutional amendment would affect all of this if it's said, like the We the People amendment Mark Pocan nationally has, federally, money is not speech, and a corporation is not only human beings have constitutional rights. So this is a real basic question.
No. Bad idea. I mean, I think Citizens United is wrongly decided for a bunch of reasons, but I don't think that corporations have no constitutional rights.
Well, no, I'm not saying they do.
But that was what as I heard you.
It says they shouldn't,
Oh, shouldn't.
Right, so he's responding to the
They shouldn't.
proposed amendment.
I mean, I don't think that the city of Milwaukee should be able to come in and take somebody's property because they happen to be a corporation. I think corporations should be allowed to advertise their products. I think they should be allowed to speak out on issues that affect their basic business. I think that's a terrible idea. I have done a draft of a constitutional amendment that's not going to pass, which basically says that the Congress and the state shall have the authority to regulate campaign finance, make reasonable rules for campaign finance spending. It's not exactly what it says, notwithstanding the First Amendment or on top. And I think that would be a way to do it. But excluding corporations or trying to do anything on that side seems to me a bad idea. It may be that unless somebody unless the court changed its views, people think that we may need to make an amendment. I don't know whether we've gotten to that point or not.
You're saying they should have constitutional rights, if that's what the founders wanted, that
Sure, of course it is.
of course. Constitutional rights, not other rights.
Sure, of course it is. I mean, corporations are founded by people, and the people have rights, and they didn't lose them just because they organized as a corporation. You can't take their property just because it's a corporation.
Okay.
But anyway, but I want to make one quick point. Alan gets nervous at words like integral. I get nervous at words like reasonable.
But I'm talking about legislation, and you're talking about judicial act.
No, I'm talking about constitutional amendments.
That's the highest form of legislation.
Yes, please. Can you hold the rim down and state your question? Well, okay.
It follows up on this. The money equals speech thing. I had heard Justice Stevens came out for an amendment that said money doesn't equal speech. And I'm interested as to how he voted in Buckley and if that means anything to us, and we should consider it. And then the bigger question is, did the founders really think money equals speech?
Stevens did not vote in Buckley.
He wasn't on the court.
He wasn't on. There have been 19.
Well,
he was, but he wasn't there, I think, for the argument
Yes,
or something.
he was confirmed in late '75, and he was. And the opinion came down in January '76, but he did not participate.
You know, I just sort of argue from authority here. There have been 20 justices sit on the court since Buckley. With the exception of Stevens, every one of them agrees that this is a First Amendment issue. You know, you can't, for example, say, well, we're not going to ban movies, but we're going to make it illegal to show pictures on celluloid or put them on DVDs, right? And then say, oh, we're not regulating the speech, you know, you just can't actually make a movie. And it's the same thing. Obviously, if you try to limit spending precisely because people are using it to speak about politics and spread their message, then you have a First Amendment problem. Money is speech is sort of a shorthand for a much more complex relationship that the court has described in somewhat more complex terms. I don't think the court has ever flat out said money is speech, but it has repeatedly made clear that they can be deeply entwined.
I agree.
Other questions? All the way in the back. You're going to have to stand up, please, and can you just wait for a moment, Art, while Ryan gives you the microphone?
Thanks. Is there any constitutional impediment to a requirement by either Congress and or the Federal Communications Commission mandating that broadcast media give public donated, whatever, non-charging time for candidates, either in general or prorated based on how much money they're receiving from purchased airtime for candidates?
Do either of you want to take that up? The current permissibility?
Well, I'm not dying to from a constitutional standpoint. I will just make more of a policy point here. Essentially, what you're doing if you do that, right? First, I'm not sure I buy into this idea that the airwaves, quote, belong to the public as opposed to the people who've invested large sums of money to give them their value. I think there are a lot of complex issues there, and that's why I don't really want to go into the constitutional aspect. But from a policy standpoint, essentially what you're doing then is you're putting a burden on a small group of corporations, broadcasters, and maybe some individuals as well, right? A small group that is essentially paying a tax. That is, they're going to have to charge people more or something, right, to make up for the lost revenue from giving this free advertising time. So essentially, rather than a broad-based tax on all of us to subsidize our elections, we're going to put a narrow-based tax on a specific little group of people. And then what we're saying to the candidates on the flip side is this subsidy you are getting in free airtime, you can use only for broadcast ads or broadcast time, debate time or something. Whereas many people feel like, wouldn't it make more sense if campaigns spent more time sending people door to door and doing old-fashioned campaigning and so on. So I'm not sure, if one wants to have the government subsidize campaigns, I'm not sure that other than political expediency gives any reason why one would want to do that through mandatory free airtime rather than having a broad-based subsidy that is then given to candidates and parties to spend in whatever way they deem effective to reach out to voters.
Yeah, the problem, of course, is there's no such a thing as a free lunch, and there's no free airtime. Somebody is paying for it, and that whether that means raising the rates on other candidates, raising the rates on people who get independent expenditures, or passing it on to somebody else through other advertising rates. Somebody's paying for it, and the question is who should be paying for it. I don't think that given our current political situation that's where I would want to spend the political capital to try to change our system around, particularly given the fact that they surely would have a lot of difficulty applying that to the non-over-the-air broadcast media, and that rationale was devised when we had the limited spectrum, and whether the Red Lion case and the others that involved limitations, for example, the ban on cigarette advertising on television, whether that would be upheld today or not, very dubious given the internet and television, cable TV and everything else. So I'm not sure that it would be unconstitutional, but it doesn't strike me as being worth the political fight or very promising in terms of helping the system.
I want to make one more quick point.
Please.
Make one more quick point. If a candidate runs an ad in which he attacks your group, right? I hate Marquette Law School, or I hate these card-carrying communists of the American Civil Liberties Union, right? He gets a discounted ad rate for doing that because he's a candidate, right? If you then want to respond, you have to pay the going market rate. Right? What kind of system is that, right? That the politicians
really bad one based on the example that you gave. Please.
So I may be a little bit too young to say this without seeming a bit rude, and I just hope you don't think that I am rude. But in the idea of trying to go back to the good old days before we had campaign finance laws, I wonder how you would hope that the various governments or other entities would affect that, considering the fact that we have had multiple decades with these laws in effect, and the public has come to think of campaign finance in a very different way than they did prior to the laws.
I think you just stop bloodletting. Right, and you'll have some physicians that say, I can't believe we're not bloodletting anymore. No wonder everybody's getting sick. But that's not how it's going to work. I think we'll find that we have a healthier democracy and people die. I think one of the great fears, by the way, of some people who favor a lot more regulation, this is not only more than I favor, but more probably than Alan favors, is that people will get used to Citizens United and realize, hey, the sky didn't fall. McCutcheon, the sky didn't really fall. A lot of people say, oh, our campaigns are terrible, but if you think back, are they worse than before? In fact, they're not. Since Citizens United, turnout's gone up. We've had more competitive elections, higher turnover in Congress. You start looking at those actual mechanisms. And I hear people saying over and over, the disastrous, the horrible, and this has been a disaster for our democracy. But if you start to press them and say, why? How? Show me the effects, it gets much more dicey. So I think you just remove it. And I don't think your question was rude in the least.
No, it's certainly a fair question. I guess a couple things. On McCutcheon, I tend to agree with Brad that maybe you could limit, and surely if the limit had been $5 million on the total amount of money you could spend, the case would never have been brought, and the reaction would have been different. But the effect of it is going to be, I think, to funnel money into candidates, and the Republican Party and Democratic Party. By the way, the Republican Party supported that, not because they cared about McCutcheon doing this, but because they thought the money would come to them for many of the reasons that Brad has said before. As far as Brad's cause and effect relationship is concerned between the campaign finance law and all the bad things going on in our democracy, I'm not a scientist, but I am on a committee of the National Academy of Sciences, and we would not allow that kind of evidence by association.
I'm just saying you have a heavy burden of proof that you have not met. If we just look at the core correlation, do you see any benefits? I think the answer is no. So there's a heavy burden of proof.
I'll tell you where I do think that the most concern I have is corporate independent expenditures in connection with judicial elections.
In other words, I'm sorry.
And that's because the money can be spent It's not a lot of people are spending money. It's hard to raise money for judicial elections. Corporations have realized that state Supreme Courts have a lot to say about their liabilities and their ability to carry on their business in a variety of manners, and they are targeting candidates who support them. And the investment is really good. It's a smart investment in many cases, and corporations are doing that. And I think that's not good for our judicial system, which I view differently as the political system. One of the ironies is that the Citizens United issue came up in the North Carolina Right to Life case a few years before, only it was with regard to judicial elections, and the court turned it down. It would have been a much more favorable case for upholding the law psychologically if it had been a judicial election rather than Hillary Clinton.
I do want to go to the back row for a question, but I wonder, Brad, whether you want to say anything with respect to judicial elections.
No, not on judicial elections.
Okay. Daniel?
Last year for a lecture by Heather Gerken, where she argued for a stronger role for political parties. I'm wondering if you could comment on whether our current campaign finance system emphasizes candidates in the one direction too much or independent expenditures in the other. Where's the role for political parties as an institution?
Well, I think that by and large, I support the direction that Congress took in 2002 in BICRA, in which it enlarged the amounts of money could be given to political parties. I think in general, parties and candidates the money is better spent there. The trouble is that efforts to lessen the amount of money spent by independent expenditures is very hard to do because what the court has said in the Arizona Council case and others. You can create incentives to give it one way, and maybe there are some limits on how much money you can give, but it's impossible under the court's current jurisprudence to be able to limit the amount of money that are spent on independent expenditures, or even to give more money to candidates who are being outspent on the independent expenditure side. But I do agree with you that it would be better, our system would be better, and it may be that some people, if we started to have more disclosure on the C4s in particular, that the money is going to, that might encourage people to say, look, I'm not going to bother with all those C4s. I don't know what's going on. I know what's going on in the party. These are all about the party and the candidates. I'll give my money that way, and we might see less of it. But
I think you see two things here. One, the way in which the law simply keeps shifting the way in which people try to influence their fellow citizens and try to influence government. And it just creates a more and more of a complex system that's navigable only by the most skilled lawyers and consultants and so on. But I also think that the First Amendment, and one reason I think we should lightly regulate in this area, is because the First Amendment is intended to keep government out of the process of deciding, you know, really parties are better. The candidates should get a discounted rate, right? But not you citizens, the example I gave earlier. You know, the parties should do better rather than independent spending. What if you want to talk about something and the candidates don't want to talk about it? Why should you be disfavored in talking about that issue in the campaign?
So do you think that there should be different limits on the amount of money you give to candidates? Should be you give as much money as you want to anybody in any kind, in any way?
I mean, essentially, yeah, I do. And I think if you refuse to go on that, we start wanting to talk practical political compromises. There are different things, again, different limits we can put on and so on. And again, if we had high enough limits, a lot of this would simply become, relatively speaking, irrelevant. But again, I go back to, I think a major point of the First Amendment is that we don't want the government getting in here and saying, you've not really spoken enough, whereas this guy has spoken too much. And we would think it would be better if you said, rather than end your commercial by saying, give me liberty or give me death, it would be much better if you ended it by saying, I'm Brad Smith and I'm running for the United States Senate and I approve this message. That's certainly much more informative to voters than if I ended it with a rousing, give me liberty or give me death, or I will never raise your damn taxes, or the rent's too high, or something like that. And I think that this is what we want to avoid. So, you know, at this core level, you know, Heather, who I think we both know and admire and like, you know, I at least have a fundamental disagreement with that approach. Her approach is that this is something that the government should be managing extensively, just better. And my approach is this is something that the government should not be managing extensively.
When Heather was here a year or two ago, the only comment that I particularly remember from her lecture was her observing that I had told her, this was accurate enough on her part, that her speech should be 43 minutes long. So we are doing terrifically well in terms of time, but we have time for one more question from the floor, it seems to me, and an answer from both of our guests. So if there is someone who would like to ask it, Yes. Mr. O'Neill.
It's not banned, I hope. I want to pour some more flame on the fun today. One of the arguments that's currently being advanced in favor of voter ID laws, and Wisconsin's hopefully is headed up to the Supreme Court, is that we need those laws to restore the integrity and confidence in our elections. And if that is true and sincerely held belief in support of the law, about which I have my doubts, why would not that same interest be adequate to limit both contributions and expenditures when that is indeed eroding the confidence in elections?
Do either of you want to engage with Mr. O'Neill?
Well, I have a really long answer to that I'm not going to have time to give. It would involve a lot of discussion. So I'll just give the short answer, which is if it's, if, as I think you suggest, you oppose the law because you don't think integrity in elections is a value that should override people's rights, then why do you think it should do so in the campaign? In other words, we just turn that question around, and I'll just leave it there for now.
We'll give you the last word.
Two answers. First, not having a voter ID probably doesn't violate the First Amendment. That's the formal answer. But the answer is, if you're going to commit voter fraud, is there a dumber way to commit voter fraud than getting somebody else's ID, in which, first, it's retail fraud. You only get one vote. Second is you're going to a place where people may know you, or they may know the person whom you are impersonating. And third, they might actually have cameras there taking pictures of people. So there's just simply no evidence that this is the case, and it doesn't make any sense that people are going to commit voter fraud in that way. If you want to worry about voter fraud, you ought to worry about mail ballots, absentee ballots, where there is a possibility, but on balance, we think that most states think it gets more people to vote, and therefore it's a fair trade-off. But I don't think it's a First Amendment issue either way.
That was terrific, the entire hour, or 50 minutes as it was, and we are immensely grateful to both of you for coming in from various places east, and we will reassemble in 10 minutes.
Thank you.
All right, I think we'll get underway. Welcome back to our conference today. We're looking at Wisconsin campaign finance law and campaign finance law in general. This part of the conversation is entitled What Will Be. So we'll be looking at the future of campaign finance law in the state of Wisconsin. We'll also spend a few minutes on the future of the Government Accountability Board in this state. Joining me for the discussion today, and we're delighted they could be here because I understand there are some other things going on in Madison right now.
Why, what would that be, Mike?
Yeah. Our Speaker, Robin Voss, he's the Republican from Racine County. He's to my immediate left. Your right. And seated next to him is the Assembly Minority Leader, Peter Barca from Kenosha. So please give him a warm welcome to Marquette Law School. So I want to begin with Speaker Voss because you have said that rewriting Wisconsin campaign finance law is a priority of yours. So give people in this room a sense of how soon you want to address this and why.
Well, first of all, thanks everybody for being here today, and thanks for inviting us to be part of your panel. I appreciate that. I think that Marquette and the series that you do is super important for people to be able to understand the topic in greater depth than just being able to get a short discussion and be able to answer questions. So thanks for doing that.
You bet.
Campaign finance is something that is so important to how government operates. Most people don't appreciate it. When I look at the very basic foundation of where our country's come from, it has always been on the right of people to have the ability to get together, to elect people that they believe share their interests, advocate vociferously for their beliefs, and at the end of the day, not have somebody restrict that ability to do it. So over and over, Wisconsin, if you look at the past, we were one of the first places that had public financing of campaigns where government began to inject itself into the marketplace of ideas. Then we tried to restrict the ability of people to spend money out of their own pocket, out of those of other people's resources. And I think over time, it's had a cancerous effect because one thing that I have learned about incumbents, regardless of party, many times they try to create a system that favors their own interests to get reelected or elected as opposed to that of the general populace. So from my perspective, I would like to have the least possible restrictions on campaign finance in general, allow the marketplace to work, allow individuals to express themselves however they choose, have that marketplace of ideas be as vigorous and as open-ended as possible. I look at our campaign finance statutes, and unfortunately, they seem to be heading in the other direction. Luckily, we've had a court that has recognized recognize the value of free speech. So many of the things that were in place in Wisconsin for a long time have been struck down, as you heard from the other people who discussed things today. So from my perspective, I want to have a complete rewrite of Chapter 11. We worked with the Democrats last time. I want to give Peter Marquette credit for that. We started that effort last time around. We sat down, said what are areas that we could agree on. We actually agreed on increasing the campaign finance limits for how much people can donate to campaigns. We agreed on allowing or trying to have as a goal to strengthen political parties, because part of the problem that I have seen is that political parties have become weaker, and that I think has been bad for democracy too. And also, we agreed on something as simple as allowing online registration. So the goal of more citizen participation, more transparency through political parties being stronger, and allowing people to have easy access to registration seems like it's something that should have happened. We passed that bill on a bipartisan basis. Unfortunately, our friends in the Senate didn't take it up. But what I've learned is if you don't succeed at the first time, you go back and try it again. So now we are right back with an effort to be able to hopefully have that broader brush, because even since we passed our bill, courts have found different aspects of even the bill that we voted for unconstitutional because we increased some limits. They've basically struck many of those down. So we're going to take into account all of the court cases that have happened, and hopefully we will have an opportunity to work together as much as possible, but give the opportunity for people and for individuals to have the greatest influence on government through their own decisions, not through a governmental decision.
And again, give us a sense of how quickly you would like to address this.
I'd like to do it sometime this spring. We tried very hard to get it done almost 2 years ago in the same time frame. Once again, ran into some roadblocks in the Senate. Hopefully those have been moved. Senator Fitzgerald, to his credit, has been working with my office to try to sit down and say, okay, what's a basic framework that we can agree on? Just where are the court cases? Because I'm not an attorney. Peter's not an attorney. Senator Fitzgerald isn't. So we have to rely on experts to give us their advice. We want to, kind of take that broad brush, ask individuals what they think, and try not to rush it through, but at the same time get something done so that it can be implemented fully before we get to the next election. I don't want to pass this at the end of the session and then everybody's trying to figure out campaign finance laws as we're circulating our nomination papers.
Leader Barca, based on what Speaker Voss just said, I mean, obviously you have some agreement on revisions to the current campaign finance law, but do you think a major rewrite of the law is needed?
Well, it's good, let me say, Mike, it was good to be back here as well. I appreciate the broad interest that we have in the community on a topic that I think is fundamentally important to the heart of our democracy. And it's an issue I feel very strongly about, and I'm glad we could be together. And it is true, last time we had a great discussion when we were here, and the Speaker and I regularly do programs called Civil Dialogue, and we've been trying to elevate the debate in the legislature, and I think that's so important. And I can't think of a topic that's more important. This state has such a rich and wonderful tradition of clean, open, and transparent government. And I feel it's at risk in so many different ways. And this issue is just one of so many that I think make a huge difference in terms of preserving what's so special about Wisconsin. Now, we both live right about on the border of Illinois. And we get that Chicago television stations broadcast up in our area. And the last two governors, I don't know if they're sharing a cell together, but they are in prison together. And that's just so sad to me.
That is sad.
And you look at the corruption that takes place across the border on a regular basis, and it absolutely disgusts me. If there's one thing that I think is so important about this state, it is that notion that we've had that rich history of clean, open, and transparent government. And the transparency part is the part where we probably disagree the most. We agree on many of the points that the Speaker brought up, and we've tried to really work together on so many different issues. And we were able to make some progress last session on this issue that I think really is important. But when Citizens United was handed down in 2010, that changed the world dramatically. And subsequent to that, we've seen other decisions build upon that, which I think make our democracy far more at risk. But the interesting thing that a lot of people don't talk about, and that's that along with that 2010 disastrous decision, in my judgment, on Citizens United, there was a side decision that came along with that. And it was voted on an 8-to-1 vote, 8-to-1. So think how strongly the the Supreme Court felt about this. Only Clarence Thomas, who I think is just about against everything, he was the only one that voted no. Well, you see so many decisions, sometimes if it's 7-2, you can almost always be certain that Clarence Thomas is one of them. And it's not to attack his integrity, but he has a different approach to things, obviously. And it's not about him. The issue is that, though, 8-1. And what this side decision said is that we really believe it's important, implicit in this, is that you have transparency. That if you're going to allow no longer hundreds of millions, but now billions of dollars to come into the campaign cycles, that we should know, states should regulate, and states should make sure that we know who's funding these campaign ads. And, they call it issue advocacy. But, of course, the difference between issue advocacy today and straight political ads is so thin, it's almost impossible for the average person to discern. There's sometimes I can hardly discern it. And that's if I got to watch it 3 or 4 times to get at it. But the idea is that, for David and Charles Koch, to say that they're going to put $880 million into the next presidential cycle, think about that. Nearly $1 billion. They'll probably put more money in than both of the Democratic National Committee and the Republican National Committee will. They likely could outspend them. It's almost like a third political party. And Citizens United says that's just fine. You can create this system. But shouldn't we know, when they start running tens of millions of dollars of ads in Wisconsin, who it is that's paying for these ads? And let me point out just one more point, and I know we want to get into discussion here, but one more point that's very interesting when you think about it, is that because you don't require disclosure, you could have a lot of very serious, unfortunate things going on. You could have, foreign national money is prohibited completely. You cannot bring in money from outside countries. But if it's not disclosed, how do you know? How do you have any idea in a day of terrorism, what foreign entity might be attempting to influence this? I was a member of Congress. You voted to declare war. You voted where aid was going to go. Billions of dollars of aid. The last thing I think we need are ads coming in that potentially could have funding that we have no idea where it's coming from. And so I would say the most important change we can make is full, total transparency. That's a Wisconsin way.
We'll talk about disclosure and a number of the issues at length here in a moment. I did want to read something to the audience because this kind of gets at this issue of money, and then we'll get into some of the specifics of possible legislative changes. But I was looking at Chapter 11, and has been around for a while, and I looked at the first 2 lines of Chapter 11. It says, the legislature finds and declares that our democratic system of government can be maintained only if the electorate is informed. There's probably no one in this room who disagrees with that.
We agree on that, right?
I do agree on that.
But how do each of you feel about this next statement? Second line. It further finds that excessive spending on campaigns for public office jeopardizes the integrity of elections. How do you feel about that?
I don't agree with that. Let's just think about why we are in the place that we are. As government has grown to take over so many aspects of the basic life that every American leads, it is not surprising that as it becomes more and more powerful, people are going to be for and against its actions. So as government has grown, so has the desire to influence and spend money to advocate for your beliefs. We don't have this idea, like we used to before, where most Americans would take care of themselves. We now have a prospect where almost every aspect of your life has involvement of the federal or the state government. So I think because that has occurred almost entirely under Democrats' watch, for them to now say, we want to stop the system because we've had this huge gargantuan government, and say that that's the only direction that society can head, that's what would happen if we restricted campaign speech. Because government is already speaking every single day, telling us why we need more, telling us why they should do more for Americans. Where's the other side's ability to say, maybe the fact that the federal government is spending hundreds of millions of dollars to tell us why Obamacare is wonderful results in the other side needing to spend hundreds of millions of dollars to say, here are the challenges and the problems with it. Government, many times, is the biggest speaker in every aspect of our lives. We need to have more speech, and the only way you can do that is by private citizens banding together, having a good opportunity to try to express their viewpoint in the market that we're in. And let's remember, more than anything else, The world that we live in now is not 3 or 4 major networks. It is thousands of networks on the internet, thousands of opportunities for speech. So just to take out ads, I mean, somebody was telling me that if you think back, I'm old enough to remember that last episode of MASH, right? Where the entire country kind of watched one station. You had the discussion the next day on what happened and the impact on the series. Now, the most watched TV show last season was a fraction of that because we are so splintered. It takes a lot more opportunity to say the same thing, to hit people where they understand the topic and begin the discussion. So part of it's just inherent in government growing, and the other is the way that media has splintered in so many ways. You just have to have more of it.
He doesn't buy the premise for Chapter 11, Speaker. I know you'd like to be Speaker Barca, Leader Barca.
How would you change that redistricting law, and it will happen just like that? But he does, or big win by Hillary next time.
He does not he does not believe the argument that excessive spending jeopardizes the integrity of elections. Do you agree?
No, I vigorously disagree. I mean, I think that people, people that wrote that into our statutes, I think were wise to do so.
So who decides how much is enough?
Let me finish. The most successful and heralded politician in Wisconsin's history, fighting Bob La Follette, who was actually a proud Republican that became a little disgusted and became a progressive because he felt their party had gone too far to the right. Sound familiar? Anyway, back in 1986, Tommy Thompson ran against Governor Tony Earl and won the race. The total spent at that time, less than 30 years ago, was $3 million. $3 million. Imagine that. That was like one ad by Governor Walker's last time, probably. And the issue is that when the speaker talks about, well, we have all these other alternative news sources and outlets, I'm not sure if you mean therefore we need more money in order to get across the point. But I think, therefore, it actually gives much more of an advantage to those people that have money. And I think that when I listen to you talk about the fact that, the problem is government's gotten so intrusive, I think we forget, though, that, government is, in America at least, is of the people, by the people, and for the people. It's a one institution that you're supposed to have a voice in, that you're supposed to be able to influence. And I think the influence that the average citizen can have gets diminished enormously when you have billions of dollars being spent in national campaigns and tens, if not hundreds of millions, being spent on statewide campaigns. And I don't think that's a healthy thing. But let's just set that aside for a second. Let's just say that, okay, we're not going to be able to control that anymore because unless we change our Constitution, Citizens United is a law of the day, and we have to accept that for the time being. Well, then what can we do? I mentioned transparency, which is an important point. But the other thing we used to have in Wisconsin, which was an important and proud part of our tradition, was voluntary public financing, which had a huge impact on people because a lot of people voluntarily submitted to accept less money in order to take the public dollars that were available so that as a consequence you sort of leveled the playing field. And in many legislative races, at one time I think it was a majority, but in many of them, that's what people did. In the last contested serious Supreme Court race where Kloppenberg thought she defeated Prosser on election night, only find out a couple days later that she didn't, they both took public financing, both of them. Both Supreme Court justices, they both decided, I'm going to take this and I'm not going to have the court be influenced by all of this outside money. And you no longer have that because of a policy choice by the Republicans to say we're not going to give that option anymore. That was such an important part of Wisconsin's tradition that I think sort of leveled the playing field. So it was a clash of ideas instead of clash of money. And right now, it really has become a clash of money. And I've got a perfect example, but I think we want to get a little further along, and I'll weave that in a little bit.
You bet. And you're shaking your head as he's speaking. Well, you're nodding.
Because it's just, I understand the perspective of wanting government to decide who can speak, how long they can speak, where they can speak, and why they can speak. Because that's what Democrats stand for. Government control. That's what it's all about. I want the freedom
I'm
of
going to
it
ask
doesn't
people,
matter.
just, just if you can just kind of listen, that'd be great.
It's
Thank
okay.
you.
It's hard when people say such outrageous things. I get it, but just, let's.
It's okay. I mean, and you know what the difference is, though? That's the right that you have. You have every right to disagree with what we believe in, and you have every right to band together, to go door to door, to give money, to buy commercials, to advocate for your belief. Under his scenario, the only one who'd get to decide that is the government, because you wouldn't be allowed to give freely to somebody else. The system that they had in Arizona, as an example, allowed for public financing, but it said that if for some reason you took public financing, and so did I, and an interest group came in from the outside and wanted to buy commercials to express their opinion as to whether or not I was good or he was good, the government would give you the same amount of money, thus equating the idea to say that government is going to be the one who controls the message. That is inherently un-American. Do I believe that in the long run, every single opportunity should be given to the public to speak? Yes. But the only way for speech should not be through what the government decides.
But do you believe in Wisconsin we ever had a scenario, ever, that the government had any decision-making or limited people's ability to speak? In Wisconsin, did that ever happen in the state's history?
Yeah, the basic.
When?
Let me answer. The basic idea of campaign finance says that we are going to limit your ability to speak because somehow less speech is in the public's interest. But I don't fundamentally believe that less speech is ever in the fundamental interest. And that's the basic precept of campaign finance, basically.
But you have to acknowledge, we never mandated public finance. It was an option for people where Justice Prosser and his challenger, Kloppenberg, decided to do that. Nobody made them do that. Wisconsin never had a system where you were required to do it. It was a system where you voluntarily decided, I'm going to be willing to do this because I think that it maybe would limit the influence of outside interest. But that aside, anyway, let me add one more point. Let me just illustrate, though, where I see you've got huge problems in Wisconsin. Let me tell you about the 85th Assembly District race. You have Mandy Wright running for re-election. She had a challenger, Dave Heaton, who beat her by, 75 votes or something. And they both did a good job of fundraising on their own. They both raised about $100,000, I guess, somewhere there about. I think she outraised them by about 25%. So they both spent but roughly an equal amount of money. But the voucher groups spent at least double what they spent, probably triple, maybe 4 times as much money. And here's the interesting thing about it. I have no idea who funds these voucher groups because, of course, they don't have to disclose it. I don't know if it's, some group that wants to create a certain type of voucher group or what the story is. But here's where the problem comes in, is that this voucher group, they have every right to say, look, we need vouchers in Wisconsin. We need to slowly get rid of public schools. Public schools are bad. We only need private schools. I think that'd be terrific if they would actually run on that campaign. But they didn't run one single ad despite spending somewhere between $250,000 and $500,000 that we know about, and probably more. Not one ad said voucher schools would be better for Wisconsin, or we want to dismantle public schools. They ran ads saying Mandy Wright protested as a teacher. And isn't that awful that she actually protested what was going on in Madison? Now, something's wrong when you have unlimited money by outside groups that we have no idea who's funding these things, and they don't even run ads that have anything to do with what the group is supposedly for. They're just strictly attack ads. And that's where we've diminished, I think, campaigns. John Torinas, somebody highly respected journalist with the Milwaukee Journal, conservative, leans your way, but I think very highly of him, just wrote an editorial. And where he decried the fact that don't campaigns mean anything anymore. In front and center, he talked about Governor Walker's campaign. He said, the governor didn't run on right to work. He didn't run on dismantling the UW system. He didn't run on GAB reform, but that's his total agenda. That's wrong.
Let me, if you want to respond to any of that, I'll give you a couple seconds, but then I want to move into the specifics of what we could see in terms of legislation. Anything you want to add to that?
The only thing I would say is he is reiterating my point over and over and over. Who is going to decide what a group should run commercials on in an assembly race? Should it be the government? Should it be the Government Accountability Board saying, no, you can't run a commercial unless it deals with this topic? That's the fundamental difference in this entire argument, is that the belief that government should control and dictate, versus that of the free market allowing individuals to do it. Mandy Wright lost because she was so arrogant she campaigned around the state for other people thinking her seat was safe. That's why she lost. And if this group ran commercials saying she shouldn't have protested at the Capitol, and that was the reason that she lost, she has to stand up and say, yes, I did protest, and she wouldn't do that either. So let's just be honest in saying that if you believe government should be the one deciding what you can say, where you can say it, and how you can say it, then you side with Mr. Barca. I don't fundamentally accept that as a part of our democracy.
But my point is there should be transparency. At a minimum, let's see who's running these ads.
That's not what you were
and paying
advocating for. You were just advocating for the fact that in her race, the group should have spent things on their own side.
No, but let me be clear. Let me be clear. I'm glad you pointed that out because obviously you misunderstood my point, or maybe I didn't explain it well. I don't think anybody should regulate what they say. That's totally up to them. If they just want to run attack ads, that's totally up to them. And I actually agree with you on that point. But my point is that that's what's wrong with where we're at currently. Citizens United, 8-1 vote. Let's at least have transparency so we know who's paying for these ridiculous ads that do not elevate the debate, which is something you and I agree with. We're trying to do that in the legislature, and I commend you for that.
How do you know the voucher group paid for those ads?
Because it's disclosed. It is disclosed that the voucher.
We already have that.
But it doesn't say who pays for them. If it's the DeVos brothers from Michigan, or if it's some Arab group from Syria. We have no idea where that money's coming from because it's not disclosed, and that's wrong.
Well, let me talk about what could be in the works in terms of legislation. And I want to begin with, we might talk a bit more about disclosure in a couple of minutes, but I want to begin with points that you agree on, because you cited those earlier, that the two of you do agree on some changes to the law. Give us an example, you did before, but elaborate on one of the examples you gave on what you think can be changed, should be changed, and will be changed.
Political parties. My first experience with a political party was when I was 10 years old. My 6th grade teacher took me to my first party where I actually got to help Lee Sherman Dreyfus run for election, 10 years old. I think political parties should be much, much stronger in our state and around our country. If you have individuals who can donate to a political party, if you have corporations and unions, and in fact, in Wisconsin, unions can donate to a political party because Democrats put that in when they were in control, but businesses and corporations can't give to either political party. So there's already a bias in the system where unions can choose to participate however they want, but political parties cannot raise money from individuals for businesses. So I'd like to have a leveling of the playing field, not to disenfranchise unions from participating, but to let everybody donate to a political party. Political parties have an organization that's county-wide in most places. They have real people who step up, they run for election, they have a debate, they have a caucus, they have a convention. There is transparency in that entire process. I would prefer that we have a much greater emphasis on raising money through political parties. Now, luckily, the 7th Circuit struck down the limits that said you could only give so much to a political party. So individuals can now give substantial amounts to the Republican or the Democratic Party. I think that's good. Every one of those is disclosed. That's positive. The difference is businesses can't do that. Corporations can't do that. An LLC or a small business, a one-person business, can't decide to do that. But if you're in a union, they can raise unlimited sums to go to the Democratic Party. That's not fair. So I want to create a leveling of the playing field to greatly increase political parties. And I know that when Peter and I talked about that last fall, that's an area that we greatly agreed on, that if political parties were stronger, so would be democracy.
Why don't you take a minute to address that?
Well, no, I think we do basically agree on that point, and that was a part of an agreement that we struck, and I thought that was a positive thing that we at least tried to come together to piece together a piece that would make some sense and at least add a little more coherence to what we have. Obviously, in the issue of corporations, though, because of Citizens United, corporations give huge amounts of money, not political parties perhaps, but the amount of influence they have is growing exponentially. Now, I own stock in Microsoft, just as one of a number of companies that I own stock in. Why should corporation executives, short-termers as I call them, because most CEOs don't stay that long. They stay long enough to boost, quarterly profits, and oftentimes then they're off to their next assignment. Many do. You have many great corporate leaders that do. But my point is, as a shareholder, I own part of that company. Why should you, as a CEO, be able to make that decision and not have to come back to me as a shareholder and say, look, We want to spend money on behalf of Robin Voss. Obviously, I wouldn't agree with that.
What do you want to do with campaign contributions, limits? What do you want to do?
It's ironic. As the speaker, I get an opportunity to go all around the country and you talk to fellow speakers, Republican and Democrat. It's very, very nonpartisan when you go to these meetings. And you learn a lot about how other states work. Oregon, as an example, a Democratic state in most elections, they have no limits, period. You can give as much as you want to a candidate as you choose. All you have to do is within 24 hours disclose that you made the contribution. That ideally would be great. If we
No
could
limits.
if we could have total disclosure and at the same time let people know exactly where it came from. Now, I think that's probably not realistic because of Wisconsin's tradition. So I'm looking at something that is greatly increasing the limits to allow individuals to raise money. Giving an opportunity for them to participate, but having some reasonable restrictions so that, in Missouri as an example, or Illinois. Illinois is another interesting example that they don't actually have state money to run their capital office. They go out and they fundraise entirely to pay for their capital staff because they have accepted the fact in Illinois that politics doesn't stop when you walk inside the Capitol door. I don't accept that. I think our system is much better. But I think that you could definitely have an opportunity for more involvement. If we just take the campaign finance limits, they were adopted in the early 1970s. If you just index them for inflation, it would be 5 times where they were, just for inflation. So that would
So
mean
instead
that
of 10,000 for a statewide office, 50,000.
it could be 50. Or for an assembly candidate, instead of 500, it could be 2,500. And that would just be an inflationary increase from where the limits were set by the Democrats in the early 1970s.
Would you buy into something like that, that kind of indexing to inflation?
Well, we did agree, for legislative races as part of our campaign finance limits that it should be raised. I can't remember what we agreed on. I think we doubled it because it hadn't been raised since, I think it was 1973.
Yep.
So that makes some sense. And let me say, glad you agree with that we shouldn't have outside influences fund our staff. So if you come from a poor district, you can't raise money, you can only have a half a staff person.
Right, I agree.
Or if you come from a rich district, you could have an army of staff people. I'm glad you agree with that, and I think that's important. And I also agree, and Robin and I both, talk regularly about the idea that it is important to sort of get ideas from other states, mix and match, find out what's working elsewhere, and you and I got to take a trip to Connecticut. They have this full disclosure law where when they run these issue ads, at least they have to disclose who's paying for them.
Let's talk keep raising disclosure. I know you want to talk about it, and you just mentioned it in your last comment. What should the new law look like in terms of disclosure?
Well, number one,
written law.
Any money that goes to a political party is already disclosed. That's the current law, and that shouldn't change. Any money that goes to any individual candidate is disclosed, and that shouldn't change. But I don't know if individuals choose to band together and they want to run ads because they support AB 1, why do I, as a citizen, need to know exactly who paid for ads that are doing nothing more than informing me on one side or the other? I don't understand the basic principle. Who cares? I don't frankly care. I don't know who pays for ads on a lot of things. But I watch them, I use my own opportunity to discern whether or not they're accurate or not, and I make my opinion based on that. So I think the reason that they want to do it, many times, is they want to be able to intimidate. And that's precisely why I don't support that basic concept. Now, I chose to stand up for election. I go through it every 2 years. I put myself out there, my record, my business practices, all of those things are public because I've made the choice. During Act 10, I had people on a regular basis that boycotted my car wash. They tried to launch a boycott against my company. And then they started to go after my customers because we have to disclose in Wisconsin who the customers of our business is to make sure that we have transparency. So I made that choice. So I'm not complaining about it. It's something I accepted. I ran for re-election. But if you're a citizen who just wants to have an influence on a bill that you think is dangerous for your business, and you want to give to a group to run ads saying, don't support AB 1, why should you now have to disclose that you made a contribution to do that if you're a private citizen taking a private act? I just don't fundamentally agree with that.
So let me be clear. No, go ahead.
No,
I was going to say, let me be clear. I heard you earlier saying, that disclosure would be a great thing, but now I hear you saying that in some cases disclosure is not a great thing.
No, there's 2 different types. If you're doing something that's express advocacy, which means you are urging the defeat of me, that has to be disclosed already. That has to be disclosed. It says paid for by on the literature or on the commercial. That's the difference. But if you're a citizen who just wants to advocate for or against a bill, I think that's also the opportunity to say, you shouldn't have to tell everybody about that.
And here's the problem. These issue ads, if they obviously are not just go vote for right to work, for instance. I mean, when these ads come out, they're going to say, call Representative Voss and tell him that he should not be supporting right to work, or he should be supporting right to work, and then they go on to all these awful things that go along with it. And the issue is that you just need to have full disclosure. I see my good friend Judge Pedro Colon here. He can't give, but if his wife wanted to give me $100, as you indicated, you agree we should have to disclose that she gave me $100. So why in the world wouldn't we want someone that's putting $1 million into some issue ad up in Wausau, Wisconsin, to talk about Mandy Wright protesting versus talking about public schools, because most of the time they're not really issue ads. Just like I said before, they're not saying we need voucher schools, we need to dismantle the public schools. They're saying something very different, and most of the time they're attack ads, not really issue ads. And I know you don't want to regulate that because you don't want to tell people what to say, and I can appreciate that. And I support that, but that's where that line is so blurred today that we just need to know who these, where the money's coming from, whoever it might be from.
But Peter, here's the basic problem. You go right down the same path. We know that the Supreme Court has said express advocacy and issue advocacy are not the same. Which governmental panel should decide which ones are issue advocacy and express advocacy?
But see, now
that's what you're asking for, because there's a very definitive term. If you say vote for or vote against or all those things, that's express advocacy. If you're just informing people on positions, that's an issue ad. That's what the Supreme Court has determined.
Right.
So now what you're saying is that somehow we need to have a government panel decide that this is not really an issue ad, and we go right down the same path of saying that government, again, sticks its nose into the opportunity for people to have their opinions expressed.
But see, actually, I'm glad you made that clarification, because I feel exactly the opposite of what you're stating. I agree. I don't think we want a government panel to regulate that. I just don't agree with the Supreme Court decision. That's where I would change the Constitution so we don't make that differentiation. So when you're spending money, we have already, there's a strict prohibition. Foreign nationals cannot spend money on anything to influence issues or politicians or influence elections. Absolute prohibition. They just can't do it. Now, we don't know if they're doing it because we don't have disclosure ads. And my point is, I don't care if it's an issue ad. Just as we have for foreign nationals, the goal is to influence the policy of this country. And when you're influencing the policy of this country, the public has a right to know who's having that influence and how they're trying to influence it and how much money they're putting into it. That's the basis of Wisconsin law. That's the way, since statehood, disclosure and transparency were two of the four fundamental pillars of our laws. So I agree with you basically in many respects, but where I disagree is I don't think you can make those distinctions. We don't make it for foreign nationals, and we should not make it for transparency.
Do you think coordination in any rewrite of Chapter 11, the notion of coordination needs to be more clearly defined? Is that something that you will look at in terms of legislation?
We're definitely looking at it. Honestly, that's another situation where I think we should eliminate the coordination statute, but that is not the majority opinion in the legislature. So at this point...
Do you have Republican colleagues who don't agree with you on that?
Yeah, I mean, we've had discussions about it. I look at it this way, that if what Peter says is true on express advocacy, okay, let's not talk about issue ads because that is totally different, but on express advocacy, under current law, you can't have any coordinated effort, which means I could send out a postcard saying I support right to work. An issue advocacy group could send out a postcard, hit mailboxes the exact same day on the exact same topic. For the average citizen, they look and they say, why did you send me 2 postcards that say the exact same thing? Because they don't know the difference under express advocacy. So in most other states, many other states, they allow the coordination between a candidate and an issue advocacy group. Where they are running those express advocacy ads. I think that would probably be better for democracy, because rather than having 12 postcards hit at the very last couple days where people throw them all away, you would be able to coordinate, Peter with the unions and their allies, us perhaps with the business community and our allies, to say, let's have a coordinated message, which allows us to coordinate together like they do in most other states. Now, we've never done that in Wisconsin. I think that many people express reservations because they're afraid that there could be some kind of collusion. But on the express advocacy side, we're all fighting for the same thing, which is to have our point of view win at the ballot box. So drawing this distinction to say somehow you can't coordinate, I don't think the public accepts that that's reality, so I don't know why most elected officials should accept it either.
Want to respond to that?
Well, I really don't have too much to add. I mean, obviously, I don't believe there should be collusion. I don't believe that there should be that type of coordination. I think it's dangerous for democracy when you have it, and I'm glad you recognize that that's a majority opinion. So, there are 4 major pillars to Wisconsin finance law: source restrictions, contribution limits, disclosure requirements, and regulation of independent speech. Those were the 4 pillars that we had. So as we rewrite these laws, which, I think most people agree do need to be rewritten, I agree that they need some changes. The GAB recognizes that. I have a lot of respect for those 6 judges that are willing to sit on the GAB and dedicate their time and energy to do that. And when we rewrite it, I just hope we don't throw out the entire philosophy, the underpinnings of what our law was all about, which is to make sure that we have clean, open, and transparent government in Wisconsin.
But just even on that, Peter, I can't believe that when most of you hear the phrase regulation of independent speech, that you believe that that's the appropriate role of government. I mean, that's the basic concept that we're arguing about today, is whether or not government should be regulating independent speech. I don't know how much more fundamental to the First Amendment you can be than believing that free speech should be what our country is based on, and that government should not regulate it in a way that hampers it. It's frustrating.
Look, I'm just reporting historically. That's what's been the 4 pillars of our law. Obviously, we're going to have a very vigorous debate when we get into that in terms of where we should land. And I'm just saying the underpinnings, the most important element of it is to have clean, open, and transparent government. And that's
Should the law
what I
be
want to make
simpler,
sure.
Representative, than
Should
it
it
is
be
today?
what?
Should the law be simpler than
Well,
it is today? So
you know,
that people out there can actually understand it. If you go back and read it, it is a fairly lengthy discourse on what is and is not proper or allowed.
Well, clearly it should be more understandable, no question about it. In fact, because of the multiple decisions that have come out, it's hard at times to make sure that you understand, exactly where we fit now, because some of the laws on the books are clearly unenforceable because of court decisions. And so obviously that's a huge problem. And so, of course they should be more understandable.
I want to pick up on something that you just mentioned. You talked about the Government Accountability Board, and I think, Representative Barker, you've talked about your desire to see as legislation is created to address some of these issues, you would like to see them play an active role in that. Will they play an active role in that in terms of what you're envisioning?
The Government Accountability Board itself?
Board itself.
I just actually had a conference call this week with Judge Nickel, the chair of the board. I've spoken to not all of the GAB judges, but a majority, about what they believe is right and wrong with the Government Accountability Board. I voted for that bill thinking that the process would be better than under the old law. Remember, under the old statute, the Elections Board, the Ethics Board, they were separate. You had the Elections Board, which was half Republican, half Democrat, and basically almost always deadlocked on major topics, resulting in the staff running everything. So I had hoped that we would have a better situation where you would have independent judges injecting themselves into those decisions, so you had people who were not professional staff making decisions about elections. That's not happened.
Now the judges, as you know, the retired judges, a couple of them have written op-ed pieces
Yeah.
saying, no, that is the case, that we're very much involved and that we don't just act on staff recommendations without a lot of input. We're very much involved.
Absolutely. Let me jump in there
Well,
because I fundamentally disagree. I mean, I think that they have been actively involved, and that's what they're telling us. I mean, that would be exactly my point. I mean, I would definitely trust, and it was a good law when it was put together. Let me read you the co-sponsors of Senate Bill 2, which became the law that passed. Mike Ellis on the Republican side, John Urbanbach on the Democratic side, Fred Risser on the Democratic side, Scott Fitzgerald, now the leader on the Republican side. I can go right down the list: Rosser, Coles, Olson, Harsdorf, mainly Republicans there, but Carpenter. On the Assembly side, you had Dean Crawford, proud Republican, now the mayor. Dave Travis, strong Democrat that, was a big issue. I didn't see your name here. I must have been a mistake, typo. But no, then you had Musser, you had Cullen, you had, Dave Cullen, who I think is here, were the leaders that pushed this bill. And I thought they did a remarkable job. Now, I wasn't in the legislature there. I was off running my business, traveling the globe. But watching it from afar, I thought, my God, what an improvement that as opposed to having partisans that are there to do, whether it's a speaker's bidding or my bidding, I would much rather trust 6 retired judges. Judges, you know, when you take that oath of office, I think you view the world differently. I think you realize you have to be impartial. You have to attempt to make fair decisions. And I would trust 6 independent judges any day of the week, even those selected by Governor Walker, of whom the majority are now, over partisans any day of the week.
Let me give you a chance to respond to that.
That's okay. I'm kind of used to it. So as I look at where we are with the GAB, the Government Accountability Board has consistently made decisions that look like they are picking one side of the argument over the other, and they are not impartial. Let's just take one simple example, the ballot redesign. Last fall, in the middle of the campaign, right before we were going to have the primary, the Government Accountability Board staff made the decision that they were going to redesign the ballot. They did it in a sweetheart contract where there was no bid, no public discussion, never a vote of the Government Accountability Board, never an opportunity to have the citizens come in and say, do we like the ballot? Should it be changed? Is there a problem with this? They hired somebody who was actually a liberal activist from California to redesign the ballot. Once again, sweetheart bid, no discussion, no public input. At the end, we attempted to sue, saying, why is this happening? And the court threw it out, not because there wasn't merit, but simply because the time was too late. Don't you think that if the Government Accountability Board was actually being run by the judges as opposed to the staff, they would have fired the director on the spot, saying if you are doing something like this without our authorization, that is a firing offense. Crickets happened. Nothing occurred. Let's go back and look at what occurred during the recall elections. Simple things that are the law. Validate the signatures that are turned in during the recall process. It's the law. They arbitrarily made a decision. We're not going to verify these signatures. We just think that there's enough signatures to recall Governor Walker. They went back in and they found thousands of errors, 30,000 names that were invalid. But the Government Accountability Board said, we're not going to involve ourselves in these petty matters of whether or not these signatures are valid. During the discussion of candidates getting on the ballot, we had a situation where my colleague John Nygren was a couple signatures short to be able to run in the recall against Senator Hansen. No ability to go back and try to rehabilitate his signatures. They just said, you're off the ballot. Mandela Barnes, a couple signatures short, just this last fall running for re-election. But the Government Accountability Board said he tried and will accept the fact that he's on the ballot. All examples where they arbitrarily make a decision, not based on the fact, not based on the merit, but on the whims of those judges. And let's talk about the single most important thing that they have to do. In the law, it said that every single 90 days, when there's an investigation ongoing, they have to take a vote to reauthorize whether or not it occurred. We have no evidence, because I've done open records requests and they won't give me the records, to say where are the minutes showing that you followed the law every 90 days taking a vote to actually keep that investigation ongoing. They refuse to disclose those documents. So now we're going to have to go to court and we're going to have to sue them to get those documents so we can have the public know whether or not they followed the law. This is a system that is broken. And I promise you, before the legislature adjourns, there is going to be a dramatic rewrite of the way the Government Accountability Board operates so we can have confidence again that we don't have people who are picking one side of the equation or choosing to disregard what is plain language letter of the law and statute because they just don't feel like doing it or the staff doesn't want to bear the time to put it into.
Briefly, will that be done at the same time that you talk about some of the changes in the campaign finance laws?
Yeah, my hope is to bring up the John Doe reform, the campaign finance reform, and the opportunity for GAB reform all in the same time because they are all interrelated to the witch hunt that occurred on Governor Walker and his staff over the course of the past 3 years by rogue prosecutors doing things that any of us would consider unfair if you actually read the record.
Leader Barca, you're jotting down notes feverishly, so what do you want to say?
Yeah. Well, I mean, in a way, I'm kind of stunned. I mean, so if you think if there were partisans on that board, so you had Democratic and Republican operatives that were sitting there, how would all of this have been different? I guess that's where I'm confused. I mean, I don't understand it.
Sure. Well, two things. Under the bill that I have asked Dean Knutson in the Assembly, he's a representative from Hudson, to lead our efforts on GAB reform. And he has gone around to talk to a bunch of people. He's talked to almost all the GAB judges, as I have. He's talked to many people on both sides to find out an answer. Now, his goal would be to have 3 or 4 judges still on the board, because the concept of those judges isn't necessarily bad. They should probably have to be running for re-election, so they're in the current election process. Some of these guys haven't been on the ballot since before the invention of the internet, so they're not exactly up to the current times. What I would also say is that we need to make sure that as you are looking at where we are, the people who are on the board have to understand that they're in a partisan role, because we're in a partisan world. So what he is suggesting is individual citizens on the Ethics Commission would basically sit on those cases with the judges. But on elections cases, you would take Democratic and Republican clerks who are truly experts on elections, but also have that natural partisan inclination, if you see somebody who's doing a witch hunt, to maybe raise your hand and say, this isn't right. You're going after one side more than the other. Judges aren't doing that. And I don't know if it's for the appearance of impropriety or they're just inept. But they are not doing it right now, so we've got to figure out some way to have a check on a rogue staff that just has a witch hunt like they did in the past.
Okay, now I will respond. I mean, look, the majority of the judges that serve on this board right now were appointed by Governor Walker. The majority. What?
Yeah, but remember the process. They are, first of all, self-selected, so you have to have been a retired judge. You have to volunteer for the position. Then the circuit court, the Court of Appeals, forwards names to the governor. So it's not like the governor went out to all 5.5 million people and said, let me get the best people to put on this board. It is a super small subset of self-selected people only through the court process. So just because they're appointed by Governor Walker, you're implying they're Republican. That's not accurate.
Well, I would hope they wouldn't be Republican or Democrat. I would hope that they would be independent. That was the goal of the GAB. By the people who were authors of this bill, the goal is exactly that, to have fair-minded people. You know, you guys replaced David Deininger, Republican legislator. I served with him during my first tenure in the legislature. Loyal Republican. I can't think of many things he ever, if anything, he ever opposed through the Republican process. But your problem with him, the reason why he had to be replaced, is that he wasn't Republican enough. And I don't want judges that are strictly partisans. I want fair-minded people. Why do we trust our judicial process? Why do people honor the courts? Because we believe that people who take this role as a judge, are nonpartisan. And I wasn't going to bring up the John Doe, but look, you brought it up. I mean, let's think of this John Doe. The first John Doe, 6 people either were convicted or pleaded guilty. That John Doe worked. I would hope you'd agree with that. I am glad we had John Doe 1. Without that, 6 people who did illegal, in some cases very serious things, wouldn't be in jail, and that's where crooks belong. And what bothers me when we talk about reforming the John Doe process is now we're going to make it harder to find these crooks and make sure they're prosecuted. Now, the current John Doe, which I know the one that makes you guys the most nervous, because obviously it gets into your money tree here and the money sources, but let me remind you, it was a majority of the GAB, in fact, I think it was unanimous, if I'm not mistaken, that requested this John Doe 2. It wasn't partisans, it was a majority appointed by the governor. The lead prosecutor readily admitted he supports the governor. The prosecutorial team has Democrats and Republicans on it. So this idea that somehow it's a witch hunt is ridiculous. It's patently false. Now, I don't know where it's going to go. I don't know if anybody broke any laws in John Doe 2. It's a secret investigation. Maybe everybody's innocent, and if that's the outcome, I'm fine with that. But if people are crooks, they should go to jail.
Let's just remember, on the first John Doe, and you're right, the people who stole from veterans, which was totally unrelated to anything that was brought up in many of the other circumstances, that was wrong. I do agree with you on that. One of the people was prosecuted because during certain times on the job, she blogged. Dumb thing. Should somebody go to jail for blogging on the job and be prosecuted? I don't believe that. I fundamentally don't believe that. I think it should be something that they take up with their employer, perhaps fired, but going to jail? How about the fact that under Governor Walker, they prosecuted because they set up supposedly the secret email system? Remember that?
Right, I remember it well.
So are you as equally angry that the Government Accountability Board set up their own secret email system under the John Doe so that they wouldn't be subject to open records requests? I didn't hear the outrage from Peter Bark on that. The Government Accountability Board did that, and yet Kevin Kennedy is still on the job with the judges defending him from setting up a secret email system. Talk about the irony. They went and prosecuted people for doing that, and now they do the same thing themselves. And they justify it by saying, well, we didn't want to be subject to open records requests. Well, maybe that's exactly why the people did it under Governor Walker. Not saying it was right, but you can't say it's okay for one and not for the other. That's why the Government Accountability Board is run amok, because they are choosing to set rules for themselves that they would never, ever allow for any of us to operate under. In fact, they didn't. That's why it's got to change.
Very brief, and then we'll take some questions from the audience.
Yeah, my point would be not so fast. It wasn't that somebody was doing some innocent blogging about their trip to Hawaii, over the winter break. They were trying to influence the governor's election. They were campaigning on county time. That was the problem. The GAB isn't campaigning. You have retired judges that are there strictly to serve the public. And I think that's what we want.
Let me take some questions from the audience. Please raise your hand. Keep your questions brief, and we'll get to as many as possible. Press down on the rim, not on the button, but on the rim, and keep your finger down on it. Thank you.
Hi, I do have a question about the GAB. Remembering that the middle word is accountability, and the foundation of our country, of our government, is checks and balances. That I heard you say is the heart of democracy. So with that, don't we really need an impartial, nonpartisan, independent body looking at elections and looking at ethics? And my question would be, how can politicians be their own watchdogs? And how could that be better?
Sure. Well, here's what I would say. In Wisconsin, we have DAs who are elected as Republicans and Democrats. And I think that both Republicans and Democrats as DAs do a really good job. I think that they can be impartial and they can allow their partisanship to be a part of their job, but not all of it. And I think that that's why we're fooling ourselves to believe that just because people say they are nonpartisan, that they are. No one can separate their own personal beliefs from the way that they make decisions. It's just part of human nature. So I think in many ways it's better to have an honest discussion so that all parties are represented in the room, as opposed to this appearance of impropriety where you can make a case that I don't think that actually exists.
I agree with you. I think that it is important people in the GAB take an oath to be impartial. Now, because you take an oath, not everybody honors their oaths, but almost all people honor their oaths. Most people in Wisconsin are people of great integrity. Most people in this state, I think, take their responsibility seriously. And if you take a retired judge that spent their whole career, who then a governor, they have to be vetted, and a governor has to select, we have to trust that whoever the governor is going to pick people that they think have integrity, that when they take that oath, that they will be impartial, as they were when they were a judge, as they have that experience, that they would do that. My concern is really what the goal is here, is to take an agency, just as you stated so eloquently, that is supposed to be a watchdog, the public's watchdog, to look out for elections and ethics violations and turn them back into partisan lapdogs. I think that's a huge mistake.
Let me take other questions. Bob, yes.
I have a question on transparency, but before, I think we all need to recognize that elections are not nonpartisan. They're extremely partisan. But my question is this: in the job that I have, I call on a lot of business owners and CEOs, and we start talking about the political situations, and in several instances, they have they've made major contributions to the Republican Party or candidates or whatever, and they believe that because of that, they were intimidated by government officials, and there's some real horror stories that go along with it. Whether it be in the state, also could be an IRS audit. If everything is disclosed in terms of who they are and putting forth their ideas, what's to stop the government from coming down on them, partisan aspects of the government, to intimidate them and try and encourage them to not contribute to the Republican Party, which many of these people have said they won't do again because they're afraid of that.
Can I just make sure I understand, because I apologize, I got distracted. I was trying to remember what your position was, and Robin told me. But so you said, because I missed the premise of this, that that somebody intimidated someone not to give. What was the scenario here again?
I'm in the merger and acquisition area.
Okay.
And some of a few cases are such, really horror stories where, in one situation, the DNR came down on a minor problem. This particular gentleman gave a lot of money to the Republican Party.
Mm-hmm.
And there's some other instances like that. So if you have complete disclosure on everything, what's to stop the particular party in power to come down and try and put government regulations and things along that line to try and keep that person from giving money to the party, where if they then forcing them into the issue aspect of it, where they can do that.
I agree. I'm not sure.
So
Your concern is that the DNR, like that they would use the regulatory power of the DNR to tell like the mining company up north to not give money to Republicans anymore? Is that? I apologize, I'm not following
I'm talking about a much
this.
smaller situation, that they're not coming and telling you better not do this. We're just, all of a sudden they show up and go after a particular, in this particular situation that I'm thinking of was a minor problem that ended up costing the owner of the company $500,000 or $600,000 in legal fees plus a major fine. And he was a major contributor to the Republican Party. And the thought is there that the people wants to stop government and partisan government from coming out and going after contributors. So all I'm saying is if you have all this transparency and so forth and so on, and
Oh, I see your point
the
now.
boss said that people were, and then you get to the fact of groups intimidating his customers. I have another person that if it's disclosed, he believes that some of the customers may leave.
Mhm.
So I'm just asking
I see what you're saying.
transparency is so important.
Well, I mean, let me say a few things. I mean, first of all, as legislators and legislative bodies, we need to have accountability, obviously. And accountability is fundamental to having a government that works. And, I chaired the audit committee. Twice during my tenure, I served on that body. To me, it was my favorite committee of all time because that's where you make sure you get sort of the bang for the buck. And the speaker's just thrilled I'm bringing this up because he's going to pounce on it and say, they audited the GAB board, and we need to make those recommendations.
It was so easy.
And he's right on that. He's right on that. I'm going to say right up front, he is right on that. We should hold them accountable, as we should every agency, frankly. And, in the Clinton administration, when we passed the SBREFA law, Small Business Regulatory Enforcement and Fairness Act, I was honored that I was selected to be the first person to head this National Regulatory Fairness Program, which kind of goes to the heart of what you're saying. And the idea behind that, which was a great bipartisan effort, Senator Kit Bond, a Republican, pushed it, and President Clinton supported it, and as part of their overall reinventing government. So to get to your point, though, and how this all fits together, is that you have to have those kind of checks and balances to make sure that people are being treated fairly. And of course, in the government, we do have, a process whereby we can follow up and ensure that if somebody is, let's say, mistreating people, of course, I'll give you some more red meat. The whole IRS thing with the Obama administration, where they contended that somehow they went after conservative groups and not progressive groups, and there's an investigation underway, and we'll find out. Of course, the Obama administration has, people that testified that no, in fact, I'll show you some progressive groups that we went after too. But clearly, you do need to have those checks and balances. I agree 110% with you. But I don't think the answer is therefore we're not going to know who's influencing our democracy, and that you could have some, nefarious people or foreign nationals that are influencing because you don't have disclosure. You have no idea of it. But you do need checks and balances. I understand your concern. I think it's a legitimate concern.
I'm going to go over to this side of the room.
Red meat. You gotta hear a pulse on
Yes, go ahead.
I want to go back to something closer to the beginning of your discussion. You both agreed that we should be working to better support political parties and to make the political parties stronger. But I'm wondering how, in a system where winner takes all, we have two very major parties and a number of smaller parties that have a harder time, getting their candidates into office, would improving the political party structure help all parties, i.e. anyone who has any interest in politics, not just those who are in the Democratic or Republican Party?
That's a good point. Well, it's certainly not my intention to disenfranchise any other political party. I would want to have them all equally have an opportunity to compete in the marketplace of ideas. Wisconsin has pretty open access, as you probably know. It's very easy to get on the ballot as a third party. It's not that difficult. You have an opportunity to do it. I just don't, I think that if you look at our, the history of our country, every time a third party movement has kind of sprouted up, one of the political parties accepts the fact that maybe that's something that we should do too, and that's why the third parties have usually been morphed into one of the two traditional political parties. I think that will probably keep happening. I mean, I look at Wisconsin, when Greens decided that they wanted to run, for the most part, it hurts Democrats. I mean, I hope Greens would run everywhere. But the fact is, they probably look and say, take a bunch of their ideas, they become part of their platform, and then Greens get morphed into that.
I similarly like libertarians.
I understand. We have the same thing. Exactly. I mean, so that's where both of those parties, I think, over time, will take their position. So
no, and the speaker makes some good points here, and I think that as we were talking about this and trying to figure this out, we were mindful of that. I think, but I think your point is an excellent one. And I think it's one that we always have to be very cautious of because, especially here in Wisconsin, of any state, because the Progressive Party, is an outgrowth of the Republican Party, not being responsive to, workers and the average citizen. And they became really a force to reckon with. And we historically in Wisconsin have had times that, there were more of a third party than there were the two major parties. So I think we both actually agree, but I think it's a point that you bring up that we can't remind each other of enough, because when political parties aren't doing their job to truly have a check and balance, you do need to make sure that you're not creating a system that makes it more difficult or impossible for a third party to be created. So thank you for bringing that point up.
Anybody in the back with a question? Yes, sir. If you can hang on 1 second, wait for the microphone.
Is your position that an attack ad is entitled to less constitutional protection than an issue ad, and how do you decide that question?
I don't think it should be entitled to any less protection. My point is just that it's all the more reason why you need disclosure, though. Because, a group can claim I'm their, citizens for jobs, and, all their ads have nothing to do with jobs. And I think the public would like to know, well, who are these people running these malicious ads? The heart of democracy is accountability. When you write a letter to the editor, we have a big dispute in Kenosha because the Kenosha News has a very broad policy where you can write anonymous letters. Right. And, every other editorial board in the country, the state, I believe, or at least the major newspapers, does not allow that because they say that if you're going to express ideas, you at least should stand behind them. People should know who you are. Now, I actually agree with Kenosha News to a limited degree because part of their concern, and I think it's a good one, is that let's say you're uncovering fraud or something and you're afraid you could be fired for bringing that up. In the narrowest of circumstances, I think that makes sense. But where our dispute was is how broad it is. But I just think but I actually agree with you. I don't think you can regulate because what, I call an attack ad, Robin Voss would disagree with, and vice versa for that matter.
I mean, there's probably, I thought we were going to have another point of agreement here because.
We do actually.
But so how many of you read the Journal Sentinel and you look at all those anonymous blogs? Nobody has put their name in there. They don't normally go after citizens. They normally go after elected officials. It is not something, I've actually stopped reading them because they're kind of irrelevant because it doesn't matter. But I guess I look at that and I think everybody has a right to say those things anonymously. I think it's their First Amendment right. We're not requiring everybody who does that to disclose. It's an option that they can do if they want. I think that's the same kind of thing that we should have in democracy all the way around, not just for bloggers, but for people who want to give and run commercials too.
Other questions?
Gentlemen, on a couple of different points, if I understood correctly, Mr. Barker, you're opposed somewhat to one side having more money than the other when it comes to campaigns.
I want to have one group have more money? What do you mean?
I think you were concerned about the amount of money being spent, and you would like to see more level playing field in that respect, which was advocating for the government support of candidates. I would say that going back to an earlier topic today, is money is speaking. So I vote with my dollar if I contribute, just like I do if I buy Coke or Pepsi.
So I don't think there's too much difference
there. To the other issue, and I would like you to address that in a second. The other thing, the coordination thing that Speaker Voss brought up, that would also mean that there'd be fewer phone calls made, right?
Yeah, there would.
That would be a nice thing. But the real question is, and we also heard that there were times that free speech is trumped. Can you advertise, and you mentioned you have car washes, can you advertise that if you have your car washed at your facility, your car will last 20 years longer?
Oh, it's called fraud.
why don't we have truth in advertising and political campaigns? And the last comment, you can address that in a second. The last comment, I do want to compliment Mr. Barca for kind of expressing his thoughts about the Clinton Foundation and the contributions in there. So thank you.
You know, I guess I understand the desire to have somebody be the truth police. I do understand that, because I don't like when people say things about me that I know are patently false, and the only thing I can do is to try to defend myself. And of course, the person who's defending themselves is always given less credibility when a charge is made. So I understand that frustration. But I don't know if I ever want to go down the path that somebody gets to decide what is and what is not the truth. I kind of think that that should fundamentally be the decision that you can make about my car wash. If you think it does a crappy job, you tell your friends, you put it on a website, you can tell people, and in the end, I lose my business. I think the same thing can be said in the political situation. If somebody makes outrageous claims, there's an opportunity. The media, to their credit, has done things like PolitiFact, where even though I think it's biased sometimes, I know they try to at least show both sides. You know, I can't like everything that everybody does. So I think it should be done more in the private sector than in government coming in saying what is and what is not truth, because that is in the eye of the beholder as to whether I think it's truthful, Peter might not, and vice versa.
You have anything to add to that?
Yeah, only that, you know, I think Wisconsin has been a beacon of hope around the country for decades, because I think our election laws were well thought out. I think that they work generally, by and large, extremely well. Now, that doesn't mean they shouldn't change. Over time, everything needs to change as new realities come in. You have electronic communication. You have to analyze how that fits into the equation. But I think what made Wisconsin special was having clean, open, and transparent government, and that's just what I want to continue to argue for. Now, the one interesting point, which I don't think is a partisan issue, but it's sort of an interesting issue, and I have no idea actually where you come down on this, but you know, we actually do have laws in Wisconsin on candidates that you can't say things that you knowingly that they're false. Like, I couldn't run against Robin Voss and say, I know Robin Voss was a Grand Master of the Ku Klux Klan. Now, of course, Governor Walker would say, I've never talked to him about it, so I don't know for sure that you weren't that, but
You've been waiting 70 minutes.
we shouldn't be able to have moderators that know us that well. No, but the point being that we actually have those laws in the book, and I do think there has to be some accountability on the part of candidates. I should not be able to say something like that about him. You know, and the laws have historically been that you cannot say things that you know are untrue. Like, I shouldn't be able to say that he raised his own pay if he didn't even take a pay increase. And in fact, in the last campaign, that actually happened in some places. Now, groups can do that, and I actually agree with you. I don't think we can regulate groups, but I would be interested to see where you come down, because I do think that we do have to at least hold candidates accountable for that type of thing. And I also agree with Rob very much. I think these, you know, PolitiFacts, as much as I think they don't always get it right, but by and large they do. And I think it's good that you have groups like that.
They get it right when I am all true.
Yeah,
I feel
which is almost all.
I feel the long shadow of Dean Kearney over my shoulder here, but I'm going to take 1 minute here, because you talked a little bit, Representative Barker, about what you would like to see in future legislation. You've made the case today that you want to see transparency, you want to see disclosure. That's important. Give us 30 to 45 seconds on what ultimately this legislation will look like. General description of what you think this will look like.
My entire goal is around maximizing freedom, which means that I want to give people every opportunity that they can through the campaign process to influence the legislature. If that means banding together with friends to run an issue ad, they should have the right to do that. If that means having an opportunity to raise funds to hire people to go door to door because they can't do it themselves, they should have the opportunity to do that. If they want to give to a candidate or a political party or run for office, all of those things should be easy. I'd also like to work, the Democrats worked with us, I believe in online voter registration. I think it's a good thing that if we have voter ID, so we now guarantee that when people go to the polls, their online registration is the same person, we should be able to do that. There should be simple things like that that we can find common ground. So my hope is we find some areas of common ground we have plenty to disagree about, but I hope we focus on the first rather than the latter.
10 seconds.
Another area of agreement. Online registration. There we go.
I want to thank Speaker Robin Voss and Minority Leader Peter Barca. Thank you.
Thanks, guys. Thanks, Mike. Take care. Good job.
Have a good line. So I want to join Mike in thanking these gentlemen. That is the law as it will be, or at least as it might be, or as close as we can come today while the debate in Madison really gears up. It seems to me that together with the earlier sessions, and my thanks again to Rick Essenberg and Matt O'Neill for the first panel, and also to Alan Morrison and Brad Smith for the second, these legislative leaders really have advanced our understanding of campaign finance regulation. So immense thanks to you guys. I have a sense of how busy your schedules are. Beyond that, I do not have extensive closing words, but I do want to say two things. The first is that it is not too much to say that this is the sort of gathering that we envisioned when we first dreamed and then designed and finally built Eckstein Hall. It's a magnificent home for Marquette law students, to be sure, and that's its primary purpose, but we really do regard ourselves as a place where the community can gather for civil and intelligent discussion, and the willingness of elected officials in particular to come is something that makes that possible. The other thing I want to say is a brief thank you. You have already heard that this conference has been a joint production of the Milwaukee Lawyers chapter of the Federalist Society, the Milwaukee Lawyer Chapter, as I've been taught to say, of the American Constitution Society. I would not want you to think that there's only one member of the American Constitution Society Milwaukee Lawyer Chapter, and in fact, the evidence that there's not is that we have both Jim Gramling and Mike Sperling here. So I hope that Dan Kelly, would you stand up, please? And Mike Sperling, would you stand up? And Jim Gramling. And then also C.J. Safer, if you would stand up. These are the individuals who worked with Mike and me to design this conference. I'm grateful to all of them. I'm particularly grateful to C.J., who first came to us. I told C.J. that I needed him to sit next to me this morning, and the pretense was that I needed him to keep track of time. The reality was that I needed him close at hand in case anything went really wrong so that I could blame him. Given that nothing did, I suppose that by parity of reasoning, I'm now obligated to hand over all the credit to him. So my thanks to all of you and to all of you for being here. Without folks such as you, the 200 plus of you engaging, this would not be the public square that we have sought it to be. Thank you.